Yes.
Item number 30.
30.
Yes, my lord.
Ha.
This matter may be adjourned for the day, my lord.
Mr.
Sir, HZP Aklas.
M.S. Majumdar.
My lord, Mr. HZP Aklas.
M.Z.
HZP.
On the prayer of so and so. Your name is there.
Yes, my lord.
Oh. This matter after 4 weeks.
Master.
Please, your lordship. Lordship, I beg to mention item number 38. Lordship, I am appearing for respondent number 4 and 5. We have filed our affidavit in opposition today.
38.
Yes, lordship.
Together.
To lordship, we have filed our affidavit in opposition today morning. To lordship, we have also taken the consent of the petitioner.
I am sorry, petitioner, my lord.
Lordship, the matter may be fixed after vacation.
A date may be fixed, my lord.
What is the matter?
Lordship,
What is the matter about?
matter is that, lordship, the employees of the association, my lord, they already getting the pay commissions benefit, my lord. In the last pay commission, after last pay commission, the finance passed an notification that the employees are entitled to get the enhanced benefit, but the entrepreneurship, all the entrepreneurship had met out the benefits from their own profit. Therefore, challenging that notification.
On the prayer of M.S.
G. Swami,
Swami for respondent
4 and 5.
for respondent number 4 and 5 submits that she has filed the affidavit today.
Yes, lordship.
She would be filing. No, it's not
Yes.
possible. Have you filed
Yes, yes.
Already
lordship.
filed?
Yes, lordship. Today.
today?
Yes, lordship. We have submitted the copy.
Having is something. So she has filed the affidavit in opposition today. Therefore, praise for listing of the matter after 3 weeks. As consented, let this matter be consented by the land council for the petitioner M.S. so and so.
P.
Let
Bora.
this matter be listed after 3 weeks.
It will be fixed after vacation, my lord.
Why?
Lordship, otherwise it is difficult.
Hmm?
The listing is very
That will
difficult.
be listed. Don't worry.
Obliged.
May I please, Milord, with regards to item number 28, Milord, with
28.
yes, Milord, with con-
Ah.
the other side, my senior Milord has some personal difficulties, may it be
On
adjourned
the
for the-
prayer of so and so, so and so. Land council for the prayer. 28.
28, my lord.
This is part of matter.
Yes, my senior will appear due to some personal difficulties, he cannot appear today, Milord, may kindly, I have taken consent from the other side, Milord, may kindly.
Then we'll release from Parthar.
Lordship.
We'll release from Parthar.
Okay, Milord, then, he has some personal difficulties, he cannot appear. today.
Mr. So and so, land council appearing on behalf of Mr. Your name is there.
My name is Milord, S.S. Ahmed, my senior will appear.
Land
additionally.
council for the petitioner submits that the arguing council, Mr. M.S. has personal difficulty. Has some personal difficulty, therefore, request for listing of the matter after 3 weeks. And listing of the matter after 3 weeks. Next, since the matter was heard in part, since the land council petitioner not in a position to appear and argue the matter, let this matter be listed after. Let this matter be released from Parthar. Accordingly, it is released and be listed after 3 weeks.
Lordship, I am for WMD department here.
Mr.
MSMD Bora.
So and so. Cannot afford to keep like this.
Yes, my lord.
Doesn't.
We have also prepared the case.
Obliged.
May I please, your lordship? I beg to mention item number 8 to 16. With the consent from the other side, I beg for adjourning this matter for a week.
Why?
Due to some personal difficulties, family emergency of the engaged counsel.
Hmm?
My senior who is supposed to argue this matter had some family emergency this morning. So matter may be adjourned for a week.
What is the matter?
Regarding employment, service matter for the candidates are disabled person.
Hmm. 8 to
8 to 16. 17 is on from other council.
on the prayer of so and so, learned counsel for the so and so petitioner. List this matter after 4 weeks.
Much obliged.
Hey, please, your lordship. Lordship, I beg to mention item number 42 of the supplementary list, your lordship.
Hmm.
Lordship, what has happened is that the state has preferred an appeal over the matter which was filed previously from this. There was a judgment that was passed in that order. They have filed an appeal in that order. Lordship, but there is a delay. So the IA for delay condonation was heard yesterday by the division bench. The order has been reserved, your lordship, and it is not passed. Thereby, since that would have an effect on this writ petition also, your lordship. Therefore, I seek a short adjournment.
Now,
You have sought permission from the respondent. Your lordship.
Mr.
T. Kashyap, your lordship. Ramesh Kashyap.
T. Kashyap, learned counsel for the petitioner, submits that related matter is in session of the division bench, therefore phrase for listing of the matter after 4 weeks.
Lordship, if I may kindly pray for the 9th, your lordship, of this month.
4 weeks. 4 weeks.
Okay, then kindly fix a date.
2 weeks. 2 weeks.
Much obliged.
Praise the Lord, list accordingly.
Lordship, interim may be continued. There's an reason.
Interim order.
The stay on the disciplinary proceedings, your lordship.
Will continue.
Much obliged.
May I please, your lordship? Lordship, I beg to mention item number 18.
Hmm.
Lordship, we have received the affidavit. We wish to file a reply. 2 weeks' time may be granted. your lordship.
Did. To file reply,
Yes, your lordship.
18. And the prayer, let this matter be listed after 2 weeks, so as to enable MS so and so to file affidavit in reply. Yes,
Oblige, your lordship.
May it please, your lordship.
yes, sir.
My lord, I am mentioning a matter which is not in the list.
Hmm.
My lord, we are permitted to take steps on the respondents through paper publication,
Hmm.
fixing a date on appearance by the opposite parties on 5/2/2026.
Hmm.
My lord, what happened, my lord, instead of appearance on 5/2/2026, it was marked as listed on 5/2/26.
Hmm.
As a result, my lord, because of that order is not there specifically, in the paper publication, we cannot give that date. So
Hmm.
therefore, some,
No, when you say that list it all, that will be same.
my lord, but then whether office will do that, that's the question.
It's okay.
My lord, I'll request them. If they refuse,
Ah.
then my lord, I will come to your lordship.
Then you have to file a
Mine.
review, I mean, modification.
All right, my lord. Obliged.
Who's there? Who's there? No. Yes, just record. R.R. Kaushik, Land Council for the President. Submits that. He has an instruction. We do this writ petition. Accordingly, writ petition stands. Therefore, praise for withdrawal of the same. Praise the Lord. Writ petition, accordingly, writ petition stands. Close on withdrawal.
May I please, your lordship? Finally, the matter may be possible for time being.
What time being?
Actually, Lordship, MSG Deka is supposed to conduct this matter. She is in another court.
What is the issue? What is
Yeah.
the issue?
It's a service related matter, Your Lordship.
Huh?
The matter, it is, and the petitioner in this case was reinstated, and after then he has not, he was not getting his other service benefits. Only back wages are withheld, but his grievance is that he is not getting other service benefits.
What service?
His, and was considered only, he was considered only for subsistence allowance since during the period of the petitioner had attended his duties, and his also back wages is concerned, respondent authority have to abide by the this honorable court's order. By honorable court order, he was reinstated, and after that he was deprived from his entitlement of service benefits like absence period service benefits.
Page 19 municipality. Page 19, paragraph 8.
Ah.
The court is thus left with the inevitable conclusion to set aside the induced order. DP order. Accordingly, the induced order dated 30th May 2009 is set aside and quashed. The dead petitioner shall be reinstated in the service immediately. The period of alleged absence of the petitioner shall also be subject to such further order that may be passed by the disciplinary authority afresh in accordance with law. However, under the circumstances, petitioner shall not be entitled to any back wages.
Hmm.
Only be directed to reinstate, and his unauthorized absence would be passed by the authority, is left to the authority. Actually, it is the domain of the disciplinary authority, my lord.
Accordingly, you have held that it is, you have passed the order saying that it may be treated as
Yes,
extraordinary leave.
extraordinary, yes, my lord.
So what's wrong? What entitlements you want?
Lordship,
Nothing?
Lordship, I need some more time as because GDECA was conducting that. I am not totally aware of that was. So,
Next week, যদি নকৰে আজি,
Hmm?
আজি নকৰে নেকি? Friday.
then the matter may be possible for the day.
Nothing is there.
Lordship, kindly then sometime maybe allowed.
Be happy. You have been reinstated
Yes.
on the prayer of MS so-and-so learned counsel for the petitioner. And as consented by Mr. T.C. Chutia, learned senior government, advisor, let this matter be listed after 4 weeks.
I have
Obliged.
already spoken. my lord.
Ah,
Obliged, my lord.
Please, Lord.
Hmm.
My lord, this is the case, my lord. This petitioner is entitled to ACPS, Equal, my lord, Career Progression Scheme, my lord. Page 33 is the direction to give proposal, my lord, under this scheme. And accordingly, the proposal was sent, but it is not considered, my lord, he is retired. So he is now, page, my lord, 33, my lord.
ah, this is what?
ACPS schemes, my lord, there is a direction to send the proposal, my lord. So who have not given the promotion, they should be given financial obligation.
Hmm,
So accordingly, proposal was also sent, my lord.
hmm.
So the scheme
Where
is,
it is?
my
Where is the proposal?
proposal, my lord, scheme is, my lord, here, page 34, my lord, kindly see page,
Where the proposal was?
proposal page 46, my lord.
Hmm.
Proposal is given, my lord, from this chief engineer, Roads, submitted the proposal, my lord.
Hmm.
So here, next page, my lord, the proposal of 2 persons. Second, the Pradeep Chakraborty is the petitioner before your lordship, my lord. They are already, he joined in service in 5/4/1977 as junior engineer.
Hmm.
Then 10 years completed in 87. So no promotion is given. Then, my lord, one promotion is given in 5/9/2004. So he retired and
Yes.
Lordship, I'm appearing for PWD. Your Lordship, general is required
Hmm?
to submit the affidavit, Lordship.
Huh?
On last date, Lordship, the accountant general was to file an affidavit.
Who?
The counsel for the accountant general, Lordship.
Accountant General.
Lordship, I'm here for PWD.
Yes, who is the Accountant General?
71, my lord, only for waiting and repaired. Accounting. 10 years. On a previous date, my lord, the honorable court has to, supposed to pass this order, my lord. On previous date.
Hmm?
On previous date, they were absent, that is why order is not passed. And we're waiting for them till 4, not non-APRs, that is fixed. Why? But today, my lord, that should be that because he is a now old person, 71 years old. Let's admit it, that he must.
Where is the Accountant General, London Council for the Accountant General?
The fixed item today, that is why. The court has said.
Accountant General and the instruction.
No, this department advocate sufficient, my lord, because they send a proposal. And
That
proposal,
status has to be.
and as per my lord, the scheme.
No, on last occasion, he has submitted that the ACP is required in the matter which the concerned department is yet to furnish. Third, Mr. M.J. Baru, Land Counsel for the petitioner. MS
H. Barra.
H.
Yeah,
Baru,
Mr. P.
Learned State Council appears for
PWD Lordship.
PWD, respondent PWD. However, Learned Counsel for the Accountant General is not present. Mr. Considering that the Learned Counsel for the petitioner had sought for a time to file affidavit. On the last opinion. In the last listing of the matter. In the last listing of the matter, on the day matter was listed. In view of the absence of the petition, the sick counsel. Matter could not be taken up. Let the matter be listed after 2 weeks. In the meantime, Learned Counsel for the Accountant General to file affidavit. He said something there. The SCP is required, it has not been furnished. Let us see. Let
My
them
lord,
file. You just
next-
inform.
Next week, my lord, this was because he is
2 weeks, not possible.
fixed, and that may be fixed then, my lord, because he's a
They'll be listed, don't worry.
pension holder, my lord.
This should be listed.
And SCPS is, I have annex, my lord. They also admitted.
Are you getting the pension?
Are you getting?
Are you
the
getting the pension?
Pension is getting, my lord. But
Wait
10,
for,
11 years he
wait
is
for,
waiting.
wait
He-
for some time. Yes. Next.
Not so bad.
May I please?
Yes.
Wherein my lord petitioner was served a show cause notice in the year 1999.
Yeah.
Accordingly, I have submitted my reply,
Hmm.
show cause reply. Thereafter, they are quite silent in this regard.
Hmm.
Only in the year of 2010, my lord, when there was no progress in the
Who is for the respondent?
forest. my lord.
Inform you, where are they?
And in fact, there was a direction by this honorable court also in the year 2010, my lord. There was a specific direction to conclude the proceeding within a period of 3 months.
That has not been concluded.
Yes.
Then,
Only in the year 2020, they have imposed a penalty of and deduction of rupees 15,76,000 from my arrear salary.
has it been
Several years,
deducted?
my lord, I have not received any salary, my lord.
Has it been deducted?
Yes, my lord, already deducted from the arrear salary. And in fact, my lord, the witnesses were examined behind my back. I was not given any opportunity to cross-examine the witnesses
After retirement or before retirement?
after retirement. Everything was done after retirement.
Huh?
Everything was done after retirement. Penalty was given in the year 2020.
Initiated before this retirement.
Initiated in the year 99. Thereafter conclude the proceeding in the year 2020. In the year 2015, I was retired from service, man.
See,
My lord, if, my lord, possible, can it, lordship may fix the matter on Tuesday, if possible, because
No, it's
each
not-
and every time, my lord, they
It's
are
not
not
possible. It's not
Because-
possible.
hard pressed.
They'll go to January.
No, my lord. Then let them come, my lord, I'll do the case.
Huh?
Or some hard pressed, my lord.
Or Mr. So-and-so learned counsel for the petition.
Next
In
week,
view of the absence of the counsel for the respondents, matter could not be taken up. Mr. Accordingly, let this matter be listed after 2 weeks.
not any fixed date making, my lord,
2 weeks, January.
No.
It's not possible.
after 2 weeks. After 2 weeks then, lord.
After 2 weeks.
Please.
Yes,
My lord, by an order dated 27/11/2024, my lord. Yeah, affidavit was referred to the file.
Lordship, we will file our affidavit, Lordship, waited for Peraway's comment, Lordship.
you were granted on 27.
Yes, Lordship,
1 year back.
Lordship, Lordship,
More than a year back, you granted 4 weeks time.
Lordship.
Heard Mr. Ayer learned counsel for the petitioner. Next para, on the prayer of Mr. J.K. Goswami, learned additional senior government advocate.
Lordship,
Further, 4 weeks time is,
Lordship.
3 weeks time is granted to file affidavit as a last chance.
Lordship, Lordship, Lordship,
next.
I will file, Lordship, within the speculated period, Lordship.
So last chance.
Lordship, last chance,
Last
Lordship,
chance, yes.
the 24.
See, 1 year back, you have been granted 4 weeks.
Lordship,
Yeah, the first chance of the
It's
last.
okay. Last chance was there.
Lordship,
Obliged.
Lordship, Lordship,
Should I add more?
Lordship, 4 weeks, Lordship, then.
Huh?
Then 4 weeks,
4 weeks.
yes.
Obliged.
Lordship. May I please, your Lordship?
Lordship, item number 37, that was for withdrawal. I was on legs on another.
What's your name?
W. Armedi.
W?
Armedi.
Armedi.
Uh, So, Lordship, with liberty to file fresh, there is a new fresh cause of action.
What liberty? Then you just said.
Obliged, my lord.
May it be pleases you, Lordship. Your Lordship, instruction received, Your Lordship. I would like to place it, Your Lordship.
Lordship, matter is regarding pension.
Pensioner, Your Lordship. The arrears salary bill was duly prepared and submitted to the Treasury Office, white bill number so-and-so on dated 18/11/2025. However, the bill was rejected by the Treasury Office due to non-submission of certain required document. The necessary documents have been uploaded in the same day and the arrear bill has been resubmitted on 20/11/2025 for further necessary instruction, Your Lordship. Already, Your Lordship, required documents has resubmitted, Your
Well,
Lordship.
clause is saying that they'll complete the process within
Time frame.
within a month.
Lordship, there is another thing regarding leave encashment period. There are some mistake, Lordship, with regard to the calculation of leave encashment. So, Lordship, that instruction is required to be produced because leave encashment, they have calculated as 110 days, whereas it should be 175. That is, there is another difficulty, Lordship. Lordship may fix a short date. In the meantime, I'll obtain instruction and let them also credit the amount, Lordship. Then Lordship may close it on the next date.
This is only regarding leave and the arrear salary.
Arrears salary.
Lordship.
Whatever
Leave
leave,
encashment, Your Lordship, I will obtain instruction on the next date, Your Lordship.
Lordship may give a short date.
MS
For
so-and-so,
vacation,
learned
Your
counsel
Lordship.
for the petitioner. MS S. Das,
PDAS,
P. Das, learned counsel,
secondary education.
learned standing counsel,
Yes, Your Lordship.
secondary education, by placing the communication dated 21/11/2025 submits that the area salary bill was Treasury Office on 18/11/2025. However, due to non-submission of certain documents, same was rejected. And now the necessary required documents have already been uploaded. And same shall be uploaded on 20/11/2025, which shall be and the process shall be completed within a short period of time. Within short period, huh? It's completed shortly, huh? Mr. She submits that she may be granted sometime to obtain instructions as regards the leave encashment.
Leave encashment.
Considering above, let this matter be listed after 2 weeks. On the next day, let the council MSP does to place these, obtain it, place, obtain instruction. No, on the next day to place the instruction, huh?
I'm deeply obliged.
Maybe, Your Lordship.
Yes.
Kindly see Your Lordship, order dated, my lord, 17/11, my lord. So we need some time, my lord. In the records, my lord, we have not filed any documents, my lord. Whether, my lord, the petitioner is referred to downtown hospital or not, my lord. In the review medical board, my lord, he was found to be unfit, my lord. And one document we have annexed, my lord, it says that, my lord, he has clinically, my lord, let us see, here the letter. He didn't move, my lord. So my lord, the director has to take instruction, my lord, whether, my lord, we have referred to the downtown hospital or not, my lord. The department has, my lord, taken big the, my lord, records, my lord. So they are trying to, my lord.
What is this?
Case 193, my lord,
Yes.
medical report, my lord.
Ah.
That is in my favor, my lord.
Ah.
No, my lord. They have annexed, my lord. Yes, my lord. Page 190, my lord, kindly see, my lord.
193.
190 only for my left shoulder, my lord.
Ah.
Yes, review medical board, my lord, he was found to be unfit, my lord, for resistant movement of both the shoulder, my lord. No, my lord, left shoulder, my lord. No, my lord, page 190, my lord, kindly see, my lord. Yes.
What do you want to say?
Movement
today?
of,
Hmm?
page 190, my lord, restricted movement of shoulder left and right, my lord. Left to right, my lord. Not left and right, my lord. Left to left and not and, my lord. Apart from that, he was overweight, my lord. Kindly see, my lord, what happened in the case, my lord. Petitioner earlier, my lord, found to be medically fit, my lord. But he was not appointed. He approached this honorable court. He got the cut-off mark, but he was not appointed. He approached this honorable court. This honorable court direct the respondents to appoint the petitioner, my lord. Accordingly, the respondent appointed the petitioner, and after joining about 2 months later, my lord, they again medical examined me, my lord. In the said medical examination, the impugned, my lord, finding is given, but that is contrary to the medical report, my lord. And in their affidavit, my lord, para 11 clearly says that they took an opinion from the doctor, my lord. And this is page 88, my lord. Para 11. Para 11, my lord. You heard?
No, it's okay. What do you want today?
Hello, we
How
need some time.
I mean, how we are disputing now? We have found that this the medical review is discharged on the basis of medical RMB,
Yes, but the
medical
department is-
review board.
But department is,
Review board basis on the report of the opinion of the doctor at page 193, which apparently is
we are
incorrect.
examining the minute of issue, my lord, whether we have referred or he himself has gone to the hospital or not, my lord. That is, my lord, page 88, can you see? That's why, my lord, we are examining the records, my lord.
Cannot keep on allowing, we just get, in view of this clear finding.
That's why, my lord, on our
We
earlier,
have asked,
That's why on earlier, my lord has granted us time, my lord.
Aren't Mr. So-and-so learned counsel?
After vacation, any date.
3 weeks, 2 weeks.
Yes, my lord.
Aren't Mr. So-and-so learned
23, my lord,
counsel
he is
for
out
the
of service.
petitioner?
Since 2023, my lord, he is out of service. Next week, my lord.
Nothing will happen since you are there since 2023. Although this court has granted time to obtain instruction, comma, Mr.
As what,
Yes,
on behalf of
what
Mr. S.S. Roy, my lord.
Learned CGC,
On behalf of Mr. S.S. Roy, my lord.
SS Roy, appearing on behalf of Mr. SS Roy, submits that it may be, a respondent may be granted some more time to obtain the instruction. Mr. Praise the Lord. Take it back. The learned counsel for the respondent shall place the definite instruction on the next date.
Yes, okay. Date may be given.
After 3 weeks,
Date will be given, my lord. Otherwise, it will not come, my lord, since he was out of service since 2023, my
will
lord.
come. Give the date.
Obliged.
Yes.
May it please your lordships. May it be pleases your lordship. Your lordship, in this matter, your lordship affidavit in reply has filed your lordship. Your lordship, one judgment has been given, your lordship. Your lordship, pertaining to that, nowadays, your lordship, secondary education has not given any post to grade 4 employees, your lordship. For that, your lordship, SMDC has constituted one body, your lordship. In that body, your lordship, on the next meeting, your lordship, all the grade 4 employee list has been given, your lordship. So pertaining to that, your lordship, I needed to obtain instruction. So
Let her file affidavit, my lord. Let her file affidavit regarding this submission.
And MS Devi, K. Devi, learned counsel for the petitioner. Next para. MS P. Das, learned standing counsel, elementary, secondary education. Submits that the department is
Actually, education department
taking
নহয়, জানো
appropriate
কৰিছো।
steps
যে মই reply দিম।
by considering, by constituting a committee,
মই আৰু
board or committee,
Committee.
So far my knowledge goes, my lord, it is not fall in the education department.
committee,
Anyway, let her file affidavit.
committee to consider the cases, all the cases, consider the matter of all cases which is also a subject matter in this petition. Mr. Therefore, press for some time to obtain instruction. Mr. Considering that the department is considering that the department appears to have initiated the process for consideration with regard to the consideration of the matters pertains to the pertains to the issue in this proceedings. Let this matter be listed after 4 weeks. Mr. MS Das to standing counsel, Das to obtain instruction.
File affidavit, my lord.
Are you sure?
Yes, your lordship.
I've
And
recorded.
for that, your lordship. I will
Already
obtain
recorded, you have
yes,
said.
your
So my case is quite different, my lord, what she submits.
What can we do?
সেইটোৱে SMDC আমাৰ আমি নকৰো।
Yes.
Lordship, as a small correction, I am with due apology, Lordship, that submission that SMDC, that is not Lordship. Nowadays, a board has been constituted, so Lordship may, we may be allowed to get that instruction. That SMDC, the submission that SMDC has, that this is not correct,
Huh?
Lordship.
SMDC is not,
SMDC is not involved, Lordship.
I said
Actually,
department.
my case is that,
Yes, yes.
my lord,
I
my
said
case-
department, not
Yes.
SMDC.
Yes, yes.
Not
Dep-
SMDC.
Yes, yes.
I said department.
That no, yes. He said assembly.
Department has initiated process
Yes.
Not
to
this
consider.
department, my lord.
Now, look what happened, that all the grade 3 and grade 4 posts, they came under a board, some said recruitment board. So that board, all the grade 4 and grade 3 posts were, of all the department, they were lordship amalgamated, and that board started the recruitment process. So regarding this particular post, whether the department will do or that board will do, that instruction I'll have to bring, lordship.
Because my appointment is in the year 1994, school was for.
Anyway,
I
nowadays,
was
the
dropped,
department
then
has
it
power
has
to
been
give
com-
any
hey,
grade 4 employee.
No, no,
Point.
he
amalgamated
said
to
consider.
high secondary, yes, I mean, this
Department
honorable
initiated
already
process to
person order.
consider. Consider includes whether you should be, whether you should
Yes, my lord.
take the recruitment or.
Yes,
instead
yes,
it-
yes.
Because,
yes.
because that this honorable court has already
Obliged.
been passed an order. That order I want actually, highly obliged.
Let's see.
Yeah, please, Malad.
Yes.
This matter relates to transfer of posting, Malad. Malad, earlier also this petitioner has approached this honorable court. Malad, that order is at page 85, Malad.
Ah,
But it starts from page 86, Malad. May I read, Malad?
80?
85, Malad.
Ah. Yes.
It is, Malad, the order starts from page 86, Malad. May I read, Malad?
Hmm.
The factual part will be noted here, Malad. Malad, I am reading from paragraph 2, Malad. Page 86, Malad.
Why do you want? From where to where?
Malad, he is presently posted at Bogaigaon, Malad.
Hmm.
And there to, Malad, Naveen Nagar, Bihar, Malad.
Hmm. So,
Malad, earlier what happened, Malad, he has completed 25 years of service in the ASF as constable, Malad.
hmm.
And Malad, as per the circular, Malad, if a person completed 25 years, then he can remain in his home, Malad, state, Malad. So that's why, Malad, earlier also Lordship has directed them to reconsider his application, and although, and he has also, Malad, given a letter that he will forego his promotion if he is, Malad, he directed to remain at his home state, Malad. But that, Malad, that was rejected, Malad.
Hmm. Then
That's why this writ petition was filed, Malad.
again, your representation was disposed of.
Rejected, my lord. My
Ah.
contention was, although lordship hold that this petitioner is entitled to remain in his home state, but in spite of that, they have rejected my application, my lord.
What is that impugn order?
My lord, impugn order is at page 94, my lord. But before going to impugn, may I read this order, my lord? Lordship has already held, my lord. Before going to impugn order, my lord, page 89, my lord,
Hmm.
lordship order, my lord, page 89, paragraph 12, my lord.
Ah.
May I read, my lord? A
Hmm.
bare reading of the aforesaid provision of the transfer and posting guidelines goes to show that the personnel in CISF is entitled to be posted in the fourth tenure, remaining service in the respective home sector. The first tenure being 7 years in the units in out of home sector, and second tenure being 12 years in units in home sector, and the third tenure being 6 years in out of home sector. The personnel has to complete 25 years of posting in the home sector in the fourth tenure. Admittedly, by now, the petitioner has completed more than 25 years in the service. Thus, this court is of the view that the petitioner is now entitled to be posted in his home sector.
Hmm.
Having considered the circular which regulates the transfer and posting of the personnel in the CISF, I find that the personnel in CISF is entitled to be posted in the home sector in the fourth tenure, that is remaining service.
Hmm.
It is settled position of law that transfer order is not to be interfered unless same is vitiated by malafide or is made in violation of statutory provisions. Guideline does not have any statutory force and are not enforceable. However, it may be interfered in case of infraction of professed norms or career prospects, although the petitioner may not have an indefeasible right to claim for transfer and posting in the home sector in terms of the guidelines, as the same provides that out of the home sector and home sector tenure for posting in respect of the person subject to availability of vacancies, operational and administration needs a new injunction. The authorities have followed the circular dated 25/9/2017 in effecting transfer and posting and relied on the impugn order, which appears to be professed norms. This court is of the view that the grievance of the petitioner required to be revisited as lapse of time by now, the petitioner has completed 25 years of service. In view of the foregoing discussion, this passage of the considered view that the grievance of the petitioner needs to be relooked by the respondent authorities. Then Lordship directed to submit a representation, then I have submitted, then my lord, impugn order is at page 94, my
90?
4. My lord, relevant will be page from 96, my lord.
Long.
Long order, my lord, Lordship may directly come to page 96, my lord. I am reading from paragraph 9, my lord. And whereas I have carefully gone through the records in the file, the petitioner belongs to district Nagaon, Assam, which comes under the northeast sector. The petitioner has completed 13 years, 5 months in the out-of-home sector and 14 years, 6 years in home sector. And whereas the petitioner is serving in fire wing of CISF and only one fire wing unit, that is CISF unit BGTPB, Bogaigaon, is available in his home sector. It is worthwhile to mention here that the petitioner is posted at CISF unit BGTP Nagaon with effect from 6/6/2016. He has already served in this unit 8 years, 7 months. Further, he has also earlier served in the unit from 1/7/2010 to 31/10/2011. Thus, overall, the petitioner has completed 9 years, 11 months in the said unit, although the prescribed tenure for an enrolled member of the force in a unit is 3 years. And whereas since no vacancy in the rank of HC fire was available in any sector, the petitioner was ordered for promotion from posting to the rank of HC fire to Eastern sector, right? This order number so and so dated 18/12/2020. And further, he was allotted CISF unit DRBCL Navin Nagar by the Eastern sector, right? Dated so and so. And whereas appropriate to mention here that the petitioner is willing to forego his promotion and seniority, subject to being allowed to remain posted as constable fire at BGTP in Bogaigaon, Assam for the rest of his service, and also taking into account the fact that he has already completed more than 25 years of service, that is 27 years, 11 months, under the provision of DOPT, OM number so and so dated 10/4/1989, the petitioner has to submit only written request of unwillingness for promotion, but the petitioner is willing to forego his promotion, subject to condition mentioned above, which is not acceptable. Now thereupon careful consideration of the above facts and circumstances of the case, as held on record, the request of the petitioner to retain him in the present unit in the rank of constable /fire for remaining part of service subject to certain conditions has been examined and not acceded to, being devoid of merit under the existing rules and instruction under circular number so and so.
What is this? Under the provision of so and so, the petitioner has to submit only written request of
Yes.
unwillingness for promotion, but the petitioner is willing to forego his promotion subject to conditions mentioned, which is not acceptable.
My lord, what happened in this case, my lord, the petitioner is working as constable fire in the, my lord, CISF, my lord. He was promoted to the post of head constable, my lord. But the petitioner submitted one request that he will forego his promotion and, my lord, all the seniority and benefits, my lord, only.
Yes.
My lord, this is third round of litigation.
Hmm.
Fact is that my lord, guideline which my friend has showed that for the fourth tenure he is supposed to be in the hometown. My lord, if he will read the one part of the notification which is in his favor and without reading, showing to the court that other part of the
No,
notification.
wrongly, rightly, we have held so.
Yes, my lord.
We have held so. You
My-
cannot reappoint it.
Yes. My lord, I'm coming by, my lord, step by step, my lord.
This is
Petitioner,
not a challenge to the earlier order of this court.
my lord,
Wrongly or rightly, we have passed.
no, my lord, yes, no,
We have,
my lord directed to file a representation and representation, my lord may consider he is presently in a, my lord, he was a constable, appointed as constable. Subsequently, by the order dated, my lord, 2020, he was posted, appointed as a, my lord, to the promoted to the post of head constable fire and transparent posting to the Bihar. Now, for the CISF, only one fire unit at Bongaigaon. In the entire Northeast, only one fire unit, only at Bongaigaon. Now petitioner is in the same place since, my lord, 6/6/2016,
Doesn't matter.
9 years, 6
After
months.
completion of 25 years.
No, my lord, that part.
I am not saying that this was good or bad. You have not taken to appeal. We have clearly observed that after completion of 25 years, as per your DOPT, right, guideline, he is entitled.
No, my lord,
Of course,
already,
it is subject to
yes.
the administrative and
My
other
lord,
requirements.
My lord, may kindly see, my lord, so that one paragraph, however, it may be interpreted the case of infraction, para 14, page 89, my lord, so that. What my lord, it is settled position of law that transfer order is not to be interfered unless the same is vitiated by any malified and or made violation of any statutory provision. Guidelines doesn't have any statutory force. Now what, my lord,
Then you read, however,
however,
you read, however,
yes,
it's a professed
however,
norm.
it may be interfered in the case of instruction and profess norms or career prospects. Now, my lord, my lord, kindly see one
Professional
part,
career prospect.
one part of the,
Professed norm.
no, my lord, may kindly see one part of the guideline. He has followed that part, my lord, followed 4th tenure. My lord, kindly come to page
You file a
68.
review and you file an appeal against this order, wrongly or rightly on
My
after
lord
hearing.
directed him to file representation.
Yes.
Representation, it's the authority has rejected the representation because, my lord, kindly see the, whether he has stated, I may be allowed to be remain in the remaining part of my service in the same place. My lord, others, all the other
There's no
constables,
other place
No, no.
other than Bongaigaon.
only at Bongaigaon. My lord, other person
allow
who is
him.
supposed to come to, my
Allow
lord, they have,
him.
he has, my lord, he has, my lord, blocked the other person who is supposed to come to the Newton. Other person also, my lord, may be retired. They also may have the right to come to their hometown. Enter notice one unit at Bongaigaon, and he is in the same place 10 years,
person-
9 months.
We're
No,
not
my lord, kindly see page 68. My lord, kindly come to page 68.
Yes.
Same notification, page 68, my lord,
Hmm.
Roman 16.
Hmm.
Notwithstanding these guidelines, in promotion come posting cases, CSA personnel can be posted anywhere in India.
Hmm.
Now, Roman 20. Notwithstanding to the guidelines contained in the circular, any personnel may be posted anywhere at any stage by the competent authority without assigning any reason, and these guidelines shall not come in any way of the transfer and composting. This is also a part of that notification. My lord,
Have you
If-
filed the affidavit?
yes, my lord, we have filed a detailed affidavit. One person in the same place, my lord, 10 years, 9 months. 10 years, 9 months.
Your guideline says so.
That is,
They are entitled for
My lord,
the
this is-
after 25
my lord,
years.
this is third round of litigation. Earlier, my lord, he has, whenever transfer posting, my lord, order has come, my lord, 2020, he has
Ah.
filed writ petition.
Ah.
Then stayed. My lord, may kindly peruse page 45. First transfer posting order, page 45 of the. writ
Or
petition.
Mr.
Take
So
it
and so, learned counsel for the petitioner, and Mr.
K.K. Parasar.
A.K. Prasad.
K.K.
Prasad,
K.K.
learned
Parasar.
CGC
This is him, my lord.
for the response. The pleadings are complete.
My lord, but kindly, my
Petition
lord,
is admitted for
my
hearing.
lord, he is staying, my lord, he is holding the stay order, my lord.
See,
Ki-
we already concluded, interpreted your DOP, which is according to this court was a
my lord, this
professed
is
norms.
part
You
of
have-
the circular.
he is
That the
entitled
other
to
party.
be considered on the basis of the thing. Can't help it,
Well,
you have not shown anything.
My lord directed him to file representation. We are duty bound to.
Yes, that is under challenge.
Yes, that is under challenge.
So we, according to me,
Now we are in
according
the
to this
repetition.
court, prima facie,
My lord,
you have not considered effectively because
my lord, is it, my lord,
see the case that after completion of 25 years,
but-
is entitled to be remain in the hometown.
but this is also a case, my lord, if, my lord, anywhere he has to go, my lord, this is also a part of the same notification. My lord, a person, my lord, by filing repetition after repetition third time, my lord, and enjoying the stay order, my lord, he is in the same place, my lord, 10 years, my lord. Is it permissible, my lord?
This after 3 weeks.
Obliged.
But it's, Malat, department is facing very hard, Malan, other person also facing very hard.
But after one person,
Malat,
see, I have found that
limited post firing only
the
one fire
order,
is
the
not-
impugn order you have, I mean, in the name of consideration, you have not effectively considered it.
Well, we have considered, department has considered, Malat,
You cannot
we
just.
cannot facilitate a person.
You just cannot read the last line to dispose of the representation, therefore we have disposed of. It's not that.
No, you're not that.
Consideration it's not only just mere consideration.
Malat
or
also
for-
mentioned
for-
in the order,
or for
Malat's
today,
order, he has no right.
consideration, we expect effective consideration.
Yes,
That's why we have to decide that these are the things.
and Malat may directly say that he will remain in BP posted in the, that will be better, Malat. Otherwise, Malat, department, Malat.
But are you going to tell me that
Mal-
what order
Malat-
I should pass?
Malat, I am not saying that.
Then,
But,
please,
Malat, I am not saying that.
don't
Malat,
try to
No, Malat.
be over smart.
no, Malat,
Mr. Prasad,
Malat. Department, Malat, is.
why you are
facing-
saying?
Malat,
Why are you saying that we should pass that he should allow to be remanded?
Malat,
We know our limitation.
Malat, I am not saying actually meaning like,
Please.
I am sorry, Malat, I am sorry, Malat. But, I'm sorry, Malat.
It's not that I'm not saying that you cannot submit, you make a
Malat,
submission.
Malat,
I'm just hearing, I'm interacting you.
Malat, I am sorry to that respect, but fact is that Malat, one person is.
What facts? We have considered the matter, your own guideline.
Malat,
We have already held that he's entitled. And we are discussing on that, you are just saying that just because he has not, he has submitted that the application and representation that you have disposed it of.
Malat, I'll take further discussion, Malat, this after 3 weeks.
Please,
I'm
try
sorry,
to, try to be,
Malat,
try to understand.
obliged.
Yes.
Lordship, in this matter, the affidavit is gone for waiting, it is ready. I'm just paying a short accommodation to file the affidavit.
And Mr. A.R. Learned Counsel for the petitioner. On the prayer of Mr. Ghosh,
Yes, Lordship. A.K. Ghosh.
all the time, all are recorded your name. You are keeping, keep on asking time. Further 3 weeks' time is granted to file affidavit.
Obliged.
Lordship, in this matter, the instructions are awaited.
Lordship, this
And
matter
Mr.
has been,
Swenchel and Counsel for the petition. Further 2 weeks' time is granted to.
Lordship,
obtain
on last
instruction.
occasion also, they sought the same,
Ah,
Lordship.
And help
Kindly fix a final date.
Lordship.
2 weeks.
Much obliged.
May I please the lordships?
Yes.
My learned friend has to place the records lordship regarding entitlement of the petitioner lordships.
Ah. Yes, it's already approved.
Copy.
Punishments of.
Heard Mr. F.U. Burbuya, learned counsel for the petitioner, and also heard Mr. A.K. Ghosh, learned counsel appearing on behalf of Mr.
No, on behalf of Mr. K. Paul, Lordship.
K. Kaur, huh? Then the additional advocate general. Assam for PNN at the department. This is, we're disposing of, closing it. By filing this writ petition,
What date
the
maybe this is
petitioner has
so
sought
that is
for
prepare the-
direction to pay. What is this? Minimum scale of
minimum,
pay.
minimum
To
scale of
the
pay,
grant
lordship,
a minimum scale of pay
in terms of the judgment
in terms of the
division
judgment
bench,
of
lordship.
judgment passed in WA writ appeal number 45/2024. What is the name of the party? Within bracket, Upendas.
Upendas, lordship, State of Assam versus Upendas.
State of
That's going to- Yes,
Assam
state-
versus
I am
Upendas.
providing the copy, lordship.
Bracket close. The petitioner is what? You are working as
Working as casual worker, lordships.
the petitioner
Tax collector come, lordship,
Petitioner.
tax collector come road moharar.
claims to be working as tax collector cum road mahalar. With a
Since
fixed
10/1/2005.
pay stuff. Relying on the judgment of this court in WA, in the case of State of Assam versus Upendas, reported in 2025 GLT 605. The petitioner claims for payment of minimum scale of pay, which has been granted to all the to the master road workers, work charge workers, work charge worker, and similarly placed employees working for more than 10 years. List of during the course of hearing, on the submission of Mr. A.K. Ghosh, learned counsel appearing for the respondents, to obtain instruction as it was stated that the name of the petitioner has been approved for payment of minimum scale of pay. Mr. Next prayer today, Mr. Ghosh learned counsel by placing the communication dated 10/04/12 04/2012 the Under Secretary to the Government of Assam, Panchayat and Rural Development Department submits that the Finance Department has approved the name of the petitioner amongst 840 members of casual workers for grant of minimum scale of pay. Therefore, the process for issuing necessary orders by the Panchayat and Rural Development is being undertaken. Mr. Next paragraph, considered above. No, having considered that the casual workers, and that the state has already been approved for payment of, for grant of minimum pay scale to 840 members of casual workers, including the petitioner, I'm of the considered view that and accordingly the department is under process to issue required orders granting minimum scale of pay to the petitioner. I'm of the considered view that no further adjudication in the matter would be required, Mr. Therefore, does does the writ petition needs to be closed, please tell me. According the writ petition is then closed on closed and disposed, closed, according to writ petition is disposed, please tell. Needless to observe that the department shall appropriately complete the process for grant of minimum minimum scale of pay to the petitioner within them as expeditiously as possible. The copy of the so-and-so is record and marked as documents X. Yes.
Within a period, lordship, release within
Yeah,
two.
it's okay.
No, that period, but otherwise they may not comply, lordship.
I have passed the order
Lordship,
expeditiously as possible.
preferably 3 months, lordship. I similarly situated persons getting since 2018.
Okay.
My name's earlier
Thank you,
forwarded,
thank you.
lordship, that period otherwise they may not comply, lordship.
I'll comply.
Lordship, that my humble submission, lordship.
Okay, thank you. I passed it.
Lordship,
When they are,
just expeditiously, lordship. but
when they are already accepted your grievance, why
Lordship, we have
unnecessary?
lordship disposed of, lordship, and we
Yes,
must oblige, lordship.
close it. Yes,
That period, lordship, otherwise they,
are you in 41? Are you in item 41?
no,
Then
oblige, lordship.
give a chance to other. I mean, give way to other. Yes,
Pleasure, Lordship. Lordship, this matter pertains to non-release of pension and pensioner benefits.
yes.
The
Why they have not released? Yes, who is the respondent? Elementary education. Finance. Who has to release?
elementary education.
Yes, elementary education.
Kindly allow me some time, my lord,
Huh?
to file our affidavit, my lord.
Praying for time. Lordship, but during the pendency of this writ petition, the provisional pension of the petitioner has been stopped. From last month onwards,
Is it a case of withdraw, recovery?
Lordship.
Huh? Excess amount of 1,98,000.
Lordship. So,
Had Mr. So-and-so learned counsel for the petitioner on the prayer of Mr. Talukdar.
B Talukdar,
B. Talukdar, learned standing counsel.
Lordship. in the-
Elementary.
elementary, my lord.
Elementary education department. Further 3 weeks time is granted to file
Lordship,
affidavit.
the
in-
provisional pension has been stopped after the case has been filed.
Let the
So, Lordship,
instruction come, my lord.
the provisional pension be paid again.
Why?
Lordship.
Why you have?
On the last occasion when the case was listed
After-
on
after notice, my lord, this,
5/9/2025.
Considering that the considering that the respondent authorities have unreasonably stopped the
Provisional pension.
provisional pension, it is directed that the petitioner shall be paid the provisional pension forthwith.
After, my lord,
To pay the
calculation, my lord,
provisional
because
pension
there is a
Provisional
recovery of
pension-
1,98,000, my lord,
That can
in
be done
in
if
accordance with the law,
my lord,
in accordance with
My
the
lord.
rules and law. Huh?
my lord.
In accordance rules, accordance with rule.
According to law, my lord.
Accordance with, huh? Rule is not a law.
oblige.
Yes,
Maybe the government will not.
22 Lordship, the arrear salary, pension, regular pension, everything, GPF, everything
GIS
has
is
been,
not
only the GIS is not being paid, Lordship.
Ah.
And for the GIS, the petitioner has to provide us with the GIS certificate when he was in service, Lordship.
yes, then,
But he is
Sir-
not being able to provide us with the GIS
Then-
certificate, Lordship. That is the problem we are
you
facing.
provide,
We will provide.
we'll close it. Otherwise, it's compliance.
Otherwise, Lordship, everything has been paid.
Ah,
Only
and-
the remaining
and
is the
Mr.
GIS.
JP Bora.
Purkasto,
JP Bora on behalf of Purkaster.
JP Bora, land council, land council for the petitioner. and
Ar-
MS
Lordship.
Arbora, land
Respondent
council
number
for
one.
is contentment number one. It is stated at the bar that the order of this court has duly been complied with. Order dated so and so. What is that order? What is that of the order?
Order dated 15/3/2023.
15/3/2020 passed in WPC number 3243 of 2020 has duly been complied with. Mr. It is submitted by. No, will not record it, it's up to you. You just submit the required documents. Accordingly, the contempt petition close.
Close, Lordship.
Close.
Obligation.
But you consider,
Yes.
ask them to submit. Are you getting?
Yes, I'm getting.
Wait to the Lordship.
Yes.
Lordship, kindly see the last order, my lord. We have included as respond number 5. First time he did not appear, second time he is appearing. As the respond number 5, learned counsel is appearing. And service is complete. We have filed a dusty affidavit also. Now, my
Published.
lord, now, my lord, what happened? Our last hearing was almost completed.
Ah.
Then it was realized the leave applications filed by the petitioner in the earlier school that should be produced before the court, records of leave application. So if your lordship kindly specified, give a specific order to respond number 5, counsel for respond number 5, he can produce it, my
Who
lord.
is appearing for respond number
He is
5?
appearing, my lord, for
Okay.
respond number 5.
Ah.
Ye file wakalat nama?
Today we filed Galatnama, my lord. So lordship, it may come with an admission form.
Admission form, your Lordship.
Admission form?
Heard
File our affidavit.
and Saikia,
But,
land counsel for the petitioner.
But my lord,
Uh,
there is.
And also,
I'm appearing for respondent 1, 3 and 4 secondary education.
friend.
Since observation is there in the last order,
just wait. Mr. So-and-so enters appearance on behalf of respond number 5.
আমি তো against
হ্যাঁ।
কইছি affidavit
Co-
পাইছে
the
documents
copies of application forms, leave application forms are necessary.
intimate
The earlier school where he was working earlier.
There's no order as such.
Yes, your Lordship, let the matter make.
No, my lord,
government
Because last
Observation.
occasion, what is
Order,
what is the
observation.
issue?
Service
Although you
completed.
have said taken steps, but there's no record to show that whether it was served or not. That's why this
That
was.
is my lord,
He is
affidavit
not
we have filed.
appearing also. Today he
No,
has
no, my
filed.
lord.
Yes,
Okay, we have filed a dusty affidavit, my lord.
list for admission hearing.
Deeply obliged.
Ah,
My lord,
admission, list for admission.
no, may I submit, my lord?
Sir,
Earlier-
madam, what can we do today? It's listed
No,
for
my lord.
orders.
In pursuance of the, my prayer is, my lord, that.
There's nothing,
he
no.
may be
Have you
directed-
seen the last order?
Yes, that would be- Can copy only no. Leave application, it is mentioned, my lord, regarding leave application, we have to made him party. Earlier, he was not party because he is in different school. Principal of different school has to be made party because during the course of hearing, the court realized that, my lord, the original applications has to be placed before the court. Twice it was.
So you want to file,
Earlier. I have not filed.
you want to implead somebody?
No, my lord. So, my lord, the record of leave applications of the earlier school. previous
Leave
school,
application? Huh?
It is a question of leave, section of leave, my lord.
Huh?
So, my
So
lord,
they'll file the affidavit.
affidavit, because nothing is against him, although we have made party, only to produce the record. Nothing, he is not a necessary party otherwise.
Let them say, then we'll see.
You implemented my.
How he, because when it is realized during the course of hearing that the original of the leave applications are necessary. That's why you have made party subsequently. So he need not answer all the paragraphs or nothing to do against him.
It's up to him.
Yes, I'm reading the order, my lord. Issue pertains to the power prayers of the petitioner for sanctioning the medical leave. Release the area salary and so and so. The petitioner was a subject teacher in mathematics in RCBP Higher Secondary School, Jaipur Rajabazar in the Kasa prior to posting of his present post in Anderson Higher Secondary Schools. According to the Secondary Education Department, their submission, unless the principal of the school forwards the application for leave that may have been submitted by the petitioner, the department cannot say anything. It is for that reason that the
The
principal of so-and-so
the
school
respond number
has
5
been
to produce
equated.
record.
My lord, actually there is a form, my particular form for apply.
Whatever record
My lord.
to produce the record. That's all.
What is the record? that's all.
After vacation, immediately, my lord.
Yes, after 3 weeks.
Oh, obliging.
This the matter after 3 weeks.
Unless the record is produced, the court cannot proceed. That's all.
Then don't produce.
My lord. My lord, we have also.
Don't produce.
My lord,
That's why the
definitely-
hearing is
definitely produce,
completed.
my lord.
Don't produce.
Sufficient, the original
We have
certificate.
also required to file affidavit, my lord.
File it.
Yes, my lord.
3 weeks.
Definitely, but get
Obliged.
documents also. Otherwise, waste of the court time. Can be a date be fixed, my lord? Can a date
After
be
3
fixed?
weeks. It's okay.
So we have the person in the office. Okay.
Lordship,
Hmm.
here in this case, Lordship, we received the Peraway's comment, Lordship.
And Mr. So-and-so, learned counsel for the petition. What is this? Notice served?
Here, Lordship, is fixed for affidavit, Lordship. Filing the
Yes.
affidavit, Lordship.
Mr. J.K. Goswami, learned additional senior government advisor submits that he has received the instruction. But instruction therefore press for some more time to file the affidavit.
Lordship,
in opposition.
may I
Whereas
come in,
not
Lordship?
just after 4 weeks.
Lordship, on the
For
last
filing,
occasion,
to
last
to
month
file
was given.
affidavit, for filing affidavit, huh?
Lordship, on the last occasion, last chance was given and they have stated that they have received the instruction. Lordship,
Yes, Lordship,
may I
we,
pray for
yes.
a short time, Lordship? Not 4 weeks,
No,
perhaps maybe 1 week.
no, 2 weeks, Lordship.
Because in the order inadvertently it is not reflected. No, inadvertently it was not reflected by
Oh, okay.
learned.
2 weeks, make it 2 weeks.
2 weeks, Lordship.
I said, what I said? Heard so and so, and submits that he has received the instruction, therefore, press for some more time, let's press for further, let's press for some more time, huh? Praise the Lord, eh? Praise the Lord. List after 2 weeks. In the meantime, the learned standing, learned council is, in the meantime, state said response to file the affidavit. huh?
Lordship, in the last order, Lordship, it was inadvertently one submission made on behalf of the Second Council PWD, that PW will place the record, Lordship. In fact, in the previous record, Lordship, a direction was there for the Deputy Commissioner to place the record, Lordship. So,
We are releasing from further. It's enough.
It is almost 8 or 9 occasions.
Yeah, that's what I'm saying.
no, Lordship
Only
has
the- my
already,
matter is
already
very
heard the
simple.
matter. It will not take much time.
Additional Advocate General.
That is the issue, Lordship. DC is government. So somebody is appearing the government, DC, Lordship.
What DC? You are Additional Advocate
No,
General.
next date I will make it confirm, Lordship. Next date, definitely on the next date, Lordship, I will make it confirm that the Deputy Commissioner places the record. So Lordship will take up.
We have directed to you.
Yes, but on last date, Lordships, it was inadvertently submitted by the council appearing for the PW law.
You were there.
I was not there, Lordship, in last day. One of my colleague, Ardhar, was there. Lordship, I kindly see the first paragraph. Although this writ petition is a part heard matter, Mr. Ardhar, Learned Counsel, submits that P. Nayak, Learned Standing Counsel, PW, who is appearing in this matter, is indisposed and therefore prays for adjournment of the matter. This court is not inclined to adjourn the matter. However, considering that Mr. P. Nayak, Learned Standing Counsel, was directed to produce the relevant record. In fact, it was directed to the government advocate who was representing the Deputy Commissioner, Lordship. That is the only
Then no further adjournment next week, or should I release
Lord-
from the further?
No, Lordship has already heard this matter. Lordship, this is
Not
not a.
already, not once, at least.
Yes, I,
Lordship will dispose of the
5 or
matter
6
on
days.
next week,
on
my
the
lord.
next day, Lordship will dispose of this matter.
In this year itself, my lord.
Because it doesn't look nice
Yes,
keeping the
I
matters
understand, I
further
understand.
for a long time.
I understand, Lordship.
And it creates a doubt also. Is not it?
No, nobody will doubt your
What is
Lordship.
this?
intention, Lordship. It is my
Because
fault.
basically why we keep the matter further, because somehow it could not complete, but substantially when you hear the
Yes,
matter
I understand,
and
Lordship. I
spending,
understand.
I mean,
Today it's Lordship. It is,
considerable amount of, I mean, time.
yes.
That's why we,
Today is
What
fourth,
to do?
Lordship, I decided, no?
Mr. P.K. Land Council for the heard Mr. P.K. Land. On the prayer of, it's of no use recording all these orders now.
Yes, my
With
lord.
the understanding that on next date, no further adjournment. All right?
Lordship.
On the prayer of Mr. P. Naik, then Additional Advocate General, come Standing Council PWD. Let this matter be finally listed for hearing.
Before vacation, my lord.
But before it's not possible.
It may not be possible, Lordship. My
After
friend will let
3
me know that.
weeks?
After vacation, Lord.
With a condition that the in a land standing land additional land additional AG 2 will produce the record
As directed
as
in the,
directed
Lordship may
earlier.
kindly
As
record
directed,
that date.
as directed earlier.
Lordship may kindly record the date, Lordship. From the Deputy Commissioner is mentioned there.
List the matter on
6th of January, my lord. Hearing date.
6 January একদম immediately opening not
Close.
10 তারিখ মানে দেখবেন। On
make
10
it after
10 Saturday. The next
make it after 15.
after 15.
The 15. My lord, 16 Friday.
Lordship.
Come with you.
Why Friday?
January.
If it's some in hearing date,
Then 20. Biplab, right?
Obliged, Lord.
Okay, Lordship.
yes.
They wanted to submit some judgment matter.
Lordship,
Hmm.
yes, Lordship. Thing is that the order 16 September 2024, Lordship, what has happened, Lordship, the de novo inquiry thing, Lordship.
Huh?
And the order to conduct a de novo inquiry,
Hmm.
because earlier inquiry officer already has concluded his inquiry and gave his report.
Hmm.
After that, Lordship, we have the government has ordered to order the de novo inquiry by another inquiry officer. The order, Lordship, is at page number, I'll provide a judgment, Lordship. Just before that, Lordship may kindly see page number 21 of the writ petition, Lordship. The order is there.
So what is the matter? Let me.
I have challenged the de novo inquiry
Ah,
on the ground that it is not permissible as per
Yes.
law. my lord.
relying on the judgment of this court.
Yes, my lord. That through judgment, my lord.
Vidyut Burgohai and Bhupati Ranjan
Yeah,
Mudoy.
yes, my lord.
Yes.
And now, my lord,
Why,
they want,
why de novo is not permissible?
because, my lord, de novo inquiry, they can initiate a de novo inquiry only if there is any material irregularity. Otherwise, they cannot, my lord.
Yes, that's all.
That's all, my lord.
So what is the stage?
My lord, it is still pending, my lord.
Oh, no. So-called notice. What is the stage of inquiry?
It's
What
pending.
was the?
De
No, no,
novo-
pending, I know.
It's not
De
completed.
novo is pending. The earlier inquiry, it was being.
No, that has been set aside.
The present de novo is still pending, Lordship.
Ah.
Pending.
They have just initiated,
Yes, ma'am.
just initiated.
Not initially, it is already initiated, evidence has already been taken, my lord. But there is an order not to pass any,
Stay.
not a stay.
That's why I'm asking, what is the stage of proceedings?
It's
You have
almost,
just,
it's almost completed, my lord.
say so.
Yes.
We said just initiated
Not
and all.
initiated, ma'am. So almost completed, but there is a court's order not to pass any adverse orders. So
Evidence, everything is over.
Over, ma'am.
It's over.
Yes, ma'am.
Only order has to pass.
Yes, ma'am.
Let them complete what's there.
No, well, how can they complete? There is a interim order in this regard. And your lordship.
That's why we'll allow them to complete the process.
No, it's not.
If it's complete, what's there?
No, well, it's not permissible, my lord.
Except to say that to rectify the material
Irregularity.
irregular, that's all.
That's all, my lord.
We'll say that although it provides, but then since the disciplinary proceedings has been completed, then they pass appropriate orders.
Right.
You have participated.
My lord,
De novo.
I have participated.
Then
At the very beginning, I have challenged it, and the court says without the leave of this court.
you challenge that outcome if it is not if it is
Subject to the
against you.
outcome, that order is also there, no adverse order passed, that is also there. Now, your lordship, kindly dispose the case on merit, your lordship.
You
Yes.
dispose it of directing them to complete the inquiry.
In a period of 1 month or 30 days.
But but it's against the law, Miller. How can they complete?
Hmm?
Against the law, Miller.
What they against the law?
Because they cannot proceed.
Show us there is no material irregularity.
Yes, ma'am, that's what I'm showing, Miller.
Show us.
Your lordship, kindly see the impugn order, page
Hmm.
21 and HFD.
Yes.
The last paragraph. Where is the disciplinary, may I peruse me, may I read me? The last paragraph. Whereas the disciplinary authority perused the finding and found not to be.
Page?
Page 21.
21.
21.
Annexure B.
Annexure B.
Where is? Where is?
In the second read petition, my lord, not the first one. In the second read petition.
Then
Item number 27.
why two read petitions?
The earlier one is with regard to the suspension. I was suspended, my lord.
So now?
That was also challenged. Still, I am under suspension.
Yes.
Page 21 and HFB.
Are you pressing the suspension?
Right now, no. If it is allowed, it will become infructuous, Miller. The suspension order that will be regularized in Annexure B, page 21.
I mean, if it is dismissed? If it is dismissed,
If it is dismissed, my lord, then it will survive, my lord.
then? Yes.
Annexure B, page 21.
Yes, I've
The last paragraph.
got it,
May I
yes.
read, my lord? Whereas the disciplinary authority perused the finding and found not to be satisfactory as Sri Ajay Kumar Hendik, Inspector UB, a police were apprehended by a trap team of the Directorate of Vigilance and Anti-Corruption Assam for demanding bribe and accepting it through middleman Sri Mukhtar Hussain. Hence, the finding dated so and so is not accepted. The charges may be inquired afresh and a de novo inquiry will be conducted. Now, the question comes from that when the de novo inquiry can be initiated. There is no specific power vested in Assam Service Appeal and Discipline rules, but in the manual, my lord, in 6.181, it is stated where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed and they have caused or they may cause prejudice to the person charged, or such irregularities are likely to vitiate the proceeding, it will consider whether the whole inquiry should be set aside and a fresh inquiry is started de novo, or whether the inquiry be set aside from the stage of occurrence of the irregularity and it be recorded to be started afresh from that particular stage. Now, my lord, here, my lord, only because the disciplinary authority is not got a favorable inquiry report in his favor, my lord. That's why he has ordered to initiate.
What is that rule?
Manual, my lord, 6.18.
Departmental proceedings.
Yes.
6 point?
8.
Press further inquiry.
Yes, ma'am.
Yes.
My book is there. It has to be on.
But it is not on your continuing. Same. Is it same? Point?
6.18.1.
Huh?
6.18.1.
Hmm.
507.
Press further inquiry. Yes.
On a meaningful reading of this comes that unless there is a material irregularity, they cannot go for de novo inquiry.
Yes.
And this provision has been, my lord, has been discussed in the judgment of
We have seen it
Pati
already.
Ranjan Murdoi versus State of Assam. In para 10 of the judgment, my lord.
Yes, yes.
May I read that?
No. We have seen it last occasion. That's why we have granted.
Yes,
Thank you.
Lordship, my friend, Lordship, here in this case to order a de novo
Did you
inquiry.
place the judgment?
My lord, I have, my lord.
You just give the copy.
Yes.
Yes.
Lordship, so in order to pass an order for de novo inquiry, one is material defect, second is lapse in procedure, Lordship. Lordship, this is a judgment, Union of India versus P. Bhagya Ranjan. Lordship, where it has been stated, Lordship, the reasoning adopted by the division bench was plainly incorrect. Whatever may be the powers of the appellate authority, the disciplining authority will have to be satisfied with the procedure adopted by the inquiry officer before passing an order. It does not stand to logic that in a given case, appellate authority could order a fresh inquiry and not the disciplining authority at whose instance inquiry began. And he is
Maybe under which rules? Under any rule?
basically rule 9. This case is filed under, Lordship, basically like a CRPF rules, Lordship.
Ah,
CRPF.
Because we have in a different rule.
But Lordship, the law part, Lordship, basically
We understood, but then this is specific to your own law.
not basically on this Assam manual, Lordship, but it is on CRPF, Lordship.
That's what I'm saying. That's why the particular provision is there. Your Assam manual has particular provisions which has been interpreted by this court already.
But this is
That is what he's saying. That is normal and depends on the rules to rule. Right?
Lordship.
Whatever you are trying to project, it may be correct.
Yes.
It's a general principle.
Yes, yes, 100%.
But when it comes to his on specific provisions of the Assam manual, clearly provides, which has been interpreted by this court, that this is only on the
Material
ground
defect.
of material irregularity, or fresh inquiry can be made.
Basically, Lordship, what is-
Otherwise, it's up to the disciplinary proceedings.
No,
Of course, on the basis of
very
certain-
surprisingly, what has happened, Lordship? He was being trapped by a vigilant district. And he was being charged. Now in the inquiry, Lordship, on another hand, just like a civil court, this and this, his statement is not been proved. He has not seen this and that. Lordship, I have seen the inquiry, I have seen the finding of the inquiry report, Lordship, by Mr. that concern. And ultimately, the last sentence was that all the evidence against this were not been proved, just like a civil court. Accordingly, Lordship. So that is the only thing. So where on the other hand,
judgment. That's all. Only one judgment. You file a written submission.
Yes, madam.
Both of you.
Yes,
And you keep the judgment reserved. All right. By tomorrow you submit.
Yes, madam. I will.
The,
Yes.
right?
Obliged.
And Mr. Learned counsel for the petitioner. And Mr.
CKS Barua,
CKS Guru, learned
GS.
standing court,
GS, government वगैरह sir.
government learned state council for respondents. Hearing concluded, judgment made there. Will not record your return submit, you just submit the request. Because certain submission may be missed, therefore, better use it. By tomorrow, huh?
Yes, my lord. I will.
This 26, 27, huh, madam? It's 26, 27, yes.
This is also a disciplinary proceeding matter, leading to removal from service.
This is, are you ready?
Yes.
To take time over,
It will take a little bit of time.
then some other.
In that case, my lord, let it go after vacation.
Hard mistake. Because it will, I think it will take time.
This will take a little bit of time. There are some. Lordship
Hard
can
Mr.
have it on-
HOD, learned senior counsel, assisted by Mr.
Ardas.
For the petition, and Mr.
Yes,
Mi-
sir.
Mr.
Yes, sir.
S. Not. Yeah, standing counsel.
LIC,
Standing
LIC.
counsel. Standing counsel, LIC or learned counsel for.
Learned
respondent-
counsel for them.
Learned counsel for the respondent LIC, yeah. As agreed to by the parties, let this matter be listed
The
after.
lordship may not say that as I agreed to, there is some pressure, man.
Ah,
Lordship will record any other reason, man.
okay. Then we'll say, let this matter be listed. After 3 weeks.
Let it be on 20, a fixed date may be given, 22nd of January.
In that case, 4 weeks on 22nd, 01/20/26.
Alright.
Not better will do it, otherwise. Matter is about,
Pension, my lord.
huh?
Yes, for pension.
Yes.
Petitioners, my lord, they were appointed in against substantive post. They were government employees, but the pension was not paid. Lordship will kindly see the important letter at page 26. These employees have already retired, Lordship. Page 26 is the most important letter issued by the government of India, my lord.
Are you ready, sir? This will take time or not?
My lord, I am ready.
Will it take time?
It will take only 15 minutes or 10 minutes, 15 to 20 minutes only. Because these employees are retired and they are old man. No, not getting pension. The apex could help that the pension must be given to the retired person in this
Obviously,
particular case, my lord.
it cannot be, there's no
Lordship, they are the
dispute to-
employee of state, Assam State Welfare Board, Lordship, not a government employee, Lordship.
Lordship, that I will
They are
place.
run on the basis of 50% salary fund from the central government and the 50% fund from the state of Assam, Lordship. They are
So-
run on that basis, Lordship. And Assam government has decided to close the board, Lordship. And central government has already decided to close the board, Lordship.
After retirement.
After
Board, that board, Lordship.
After their retirement.
After our retirement.
Retirement. They are retired employee, Lordship. They are
After
retired employee, Lordship. That the government of Assam is decided to close down the board, Lordship,
After the retirement,
after retirement.
then
Now they have decided, Lordship, and the funds are coming from the Lordship, central government fund and 50% and state government fund from 50%, Lordship. On that basis, they are.
what the
run.
rule says?
My lord, rule, my lord, I have annexed that page, my lord. That page C0.
Page?
Page T0, my lord, annexed B.
3-0.
3-0, my lord. Except B, my lord.
Hmm.
Lordship, definition. These rules may be called rules of the State Social Welfare Board.
What is this board?
Lordship, Annex Roman 4. Government means state government of the union territory. My lord, now, composition of the state board. Roman 1. The board shall consist of social members as may be decided by the Central Social Welfare Board. My lord, then last Roman 5. The chairperson of the state board will be selected by the chairperson of the Central Social Welfare Board in consultation with the concerned state government. For the chairperson is appointed, selected by the state and it is approved by the government of India. What's it now? Rules.
Is there any notification regarding the pension, applicability to pension rules?
Yes, yes, I'm pressing.
You come that only,
Madam,
directly.
Madam, first they are telling that we are not the government employee, but they themselves have issued the letter holding that we are government employee. I am pressing that one. Yes,
No, no.
Let me make my submission. I stay in the word for a few minutes. If I fail, that matter is different. My lord, that page of that rule, page 35. Roman 8, page 35.
Hmm.
Hello, Roman 8.
Yes.
Employees of the state board will be governed by the state government rules in terms of their service conditions. The state board will also follow the state government rules in case of other financial and administrative rules that will matter. So the state board means it is governed by the government of Assam.
Employees of the state board will be governed by the state government rules in terms of the service conditions.
Yes, my
The
lord.
state board will also follow the state government rules in case of other financial and administrative matters.
My lord.
It's not relevant. Financial and administrative matter is not relevant.
Now, that
Whether the terms of service condition may be
condition, what is the condition? 50-50, that means it was decided by the central government of India, 50% you will pay, 50% you pay. In India.
then who will pay the pension?
Regarding one of these financial benefit.
Who is liable to pay the pension?
Pension is they have to pay.
Who?
This social welfare board, government of Assam.
Board is no longer there.
Now it is closed. That is why I have brought the judgment. I will place it before the kindly see, my lord. My lord, kindly see. Budget, page 35, budget. The board shall in each year submit to the Central Social Welfare Board.
No, it's not relevant.
No, my lord, because that they are telling that they have to pay 50%. But the government of India told them to submit the bill. And the Assam government is sitting tight. Consequently, see the annexure E. This you are already submitted regarding this, how much pension they will get. Page 42, annexure E. Statement. Annexure E.
Who has prepared this? Who has prepared this?
This is prepared by them.
Who?
The Department Social Welfare Board. I am showing the signature. My lord, that page, next page 43, 42A. Kindly see that the secretary, Assam State Social Welfare Board.
This is in respect of all.
These persons.
This is in respect of all the petitioners. How many petitioners?
We are petitioner number 10, no? Present petitioner, right? Our petitioner is 11 number petitioner. And their names
What about the rest? The rest they have taken.
their names are here. My lord, I can place it. My lord, that page 43.
The Assam chairperson is still board.
Chairman is appointed by the government of India with the consideration of the government of Assam.
Okay, then.
Yes, then I will place you before lordship. Another very important factor. Also kindly see at page 62. Hello. Also kindly see page 62. This is a letter addressed to the director by the letter issued by the my lord chairperson. My lord kindly see. Concurrence to extend the pensionary benefit to the employees of Assam State Social Welfare Board. I have the honor to inform you that the government of India gave their concurrence on effect from 1/4/1979 for extensions of pensionary benefits to the state board's employees. Wherever the concerned state government agrees to meet 50% expenditures on this account, right? Government letter number so and so, copy and post. So the government of India has already issued a letter in 1979 that the employees of the state social welfare board will get the benefit of pension and will bear 50% expenditure. You bear 50% expenditure. In India, my lord, I have annexed it. 23 number of states have already given the benefit of pensions to all the employees of the social welfare board. And but due to the negligence and apathy of this social welfare board of Assam, these petitioners are victimized. That's a condition. So at page 80, my lord, very important letter, page 80. The additional chief secretary to the government of Assam, to the director of social welfare department, my lord, sir, I have the honor to inform you that the government of India gave their concurrence with effect from 1/4/1979 for extension of the pensionary benefits to the state board employees.
Same, almost same thing.
No, Lordship, sir. Kindly will see, my lord, this is.
This is by the chairperson only.
My lord, kindly see. This is, Bhutan person. The pensionary benefits have been extended to the state board employees in 21 states.
That you have read last, the same, it's a repetition of earlier.
Kindly see the article 14 is violated by them. Kindly see last but one. The pensionary benefits has been extended to the state board employees in up to 21 states. Namely Andhra Pradesh, Gujarat, Haryana, Jammu Kashmir, Karnataka, Madhya Pradesh, Tamil Nadu, Tripura.
That you have already repeated in page 63.
But that state.
63 is already, it's a repetition only.
My lord, repetition means that this.
Then you went to Prime Minister also.
No, that is attached to the.
82, Prime
Yes.
Minister. Then
Yes.
Prime Minister has desired forward here with a letter in this office guidance under the for action as appropriate. Section officer. Right? Page 83. Then Deputy Secretary. See, guidance and they received, which is accepted by the request you kindly take appropriate action. Yes.
Yes, that is you are another.
Appropriate action. Yes.
You
Then
are-
Then what happened?
Then roughly that page.
Central Social Welfare Board. The government has approved pension by state board employees with effect from so and so, subject to the condition that respective state also gives its consent to bear expenditure condition from Assam state government for bearing expenditure is still awaited. Many employees of state board have retired after a long years service and without any pension, causing lot of financial difficulty families. Executive Director, Central Social Board, yes. Then
Annexure A is the most important letter. My lord, Annexure A.
Annexure A,
A, my lord.
Page?
Page 26.
huh,
This is a letter issued by the government of India to the secretary, Central Social Welfare Board, given the building, and this very lordship may kindly let me read this letter. I am directed to say that the government has been considering for some time the question of extending the pensionary benefit, gratuity benefits to the employees of the state social welfare board, and the government of India has written to all the state government as early as in July 1978 to agree to the extension of such benefits. Since then, replies from various state government have been received. In some cases, agreeing to the proposal, and in some cases, intimating that the question is under their consideration. some states, union territories have agreed to the proposal and to meet their 50% share of the expenditure and have requested for release of the share of the Central Social Welfare Board. It was either thought that the decision in the matter may be taken after all state union territories have consented in the proposal, but due to obvious delay and continuous denial of this benefits to the employees of the state social welfare board, it has resulted into the hardship to the employees. Keeping in the view in factors in view, the department has considered this matter in consultation with the integrated finance division of the department and have decided that the pensionary density benefits may be extended in effect from 1/4/1979 to the state board employees. In cases where the state government concerned has also agreed to the extension of such benefits and also share 50% expenditure in accordance with the agreed.
This basically for release of 50% share.
Yes.
Hmm.
50% government of India has already given them to them. They are holding this, they are not releasing the money to us, the pension. That is why, my lord, 20.
As of now, I'm not able to understand
Hello,
on what basis you are claiming.
my lord.
You just say that you have shown the letters, correspondences, where it seeks to.
My lord, kindly see the judgment of the Supreme Court.
No, apart from all this correspondence, what is the law? What is the relevant notification rules which will govern your pension?
Oh, it will governed by the Assam pension rules.
Huh,
Assam pension rules may not, my lord. Assam service pension rule.
huh.
If the employees are retired, working under the government, they
So
are
as,
entitled for the pension.
so as, they are not, you are not government employee.
They are government employees. Let them say.
The board employee.
No, the appointment letter itself is not a crime issue. That we are the government employees, fine, also. Let me see, madam. Just a minute, madam. We shall be reiterated.
Where is the the appointment order?
हमारे की अरे
It's been. Sir, it's been 20 minutes. You said hardly 10 to 15 minutes.
That on the one of the honorable judges asked me whether I am appointed, I am a government employee. I have annexed that letter that I am appointed against a sanction post and I am a government employee.
Number one, you have to establish.
That letter I am searching, Lordship. My lord.
Number one, sir, you have to establish that you are government employee.
My lord, that is.
And definitely you are not a government employee,
I am a
but
government employee.
as an employee of the board falls under the definition of the government employee.
I am a government employee. They themselves have issued a letter, Lordship. I am searching that letter, Lordship. Kindly let me have some time.
Which post you have retired? Different posts.
As accountant, some of them accountant, and some of them UDA.
Okay.
They are doing more than 20 years service.
So please first search it and come back. Next case. We'll continue. Please go. Let them find out. We'll continue. It's fine because it takes time. No? You are taking some time. Therefore,
Yes,
let
sir,
them let them find out.
I'm finding out.
Yes. Yes. Hmm. Yes. What is the matter? Then we'll adjourn on the prayer of Miss MS Emberman. Then council for the release this matter after 2 weeks. What is the matter? That's why, if it is not, then in that case, not 2 weeks, 3 weeks. 3 weeks. 2 weeks not possible. Even if you say 2 weeks, not possible. We're running sort of thing. Yes. Next. Non appears for the petitioner on call. However, no, on call. MS
M. Kalita.
M. Kalita. M or N?
M.
M. Kalita, London State Council is present. List after 4 weeks. 3 weeks, make it 3 weeks.
Lordship, my senior is in court number 7. Kindly make a certificate of person. Make a certificate of person.
No. Then after 2 weeks. On the prayer of MS so-and-so, London Council, appearing on behalf of NK Kalita, London Council for the release this matter after 3 weeks.
My lord, item 33, my lord.
It's already over.
My lord, some personal appearance was given. And my lord will peruse the. Will take it.
Next week. After 2 weeks. 2 weeks, right? 33?
My lord, there is some urgency, my lord, that is why. My lord-
2 weeks, 2 weeks. Why personal appearance is there?
Yes, my lord.
Why?
Some instructions were sought, my lord, that's why. My lord,
We'll
take
see
it up
after 2 weeks, we'll see.
At 2 o'clock, my lord, we'll take it. Up.
We'll take after
My
after
lord,
2 weeks, we'll see. 2 weeks.
my lord, next week, date may be fixed, my lord. I am praying, my lord, some urgency is there.
What is the issue?
Issue regarding, my lord, the employees are terminated from service, my lord, without following the principles of natural justice, my lord. Without show cause, my lord, they have been terminated and
2
they are-
weeks.
They are suffering, my lord, like, my lord, they're
3 weeks. Make it 3 weeks. Give the date. Take the date.
Lord, next week, if I may pray. my
No,
lord.
no, it's not. Next 2 weeks too is not possible. 8 January.
Here, Lordship is a case of dismissal from service, Lordship. The respondent number 3 is yet to file the affidavit. The inquiry
Yes,
office.
may,
And if Lordship is pleased to go through the respondent number 2's affidavit, Lordship, please confirm the affidavit. Just stating of facts, Lordship.
We
Not
have
rebutting any of our point.
affidavit is ready and sent for vetting, Lordship. Kindly.
It's a listed for
Here is
hearing.
passed out.
Heard, Mr.
And Gautam, Lord.
And
And
Gautam,
Gautam.
London Council. Your name is not there.
On behalf of Mr. J. Patwari. Lord.
We have Mr. J. Patore, London Council for the petitioner. As the affidavit of respondent number
3.
3 would be required, comma. On the prayer of MS S. Barwa, London CGC.
No, Lordship,
State,
state
London
respondent.
State Council
State respondent.
is granted, is granted 3 weeks time to file affidavit.
Lordship, may this matter of 8, your Lordship.
What 8?
8th of January, your Lordship.
Cannot be.
Dismissal from service, Lordship, they yet to file, a year has passed, Lordship.
After that, it's not possible.
Lordship, at
8
least,
we have picked
in the
so
month
many
of
matters.
January, your Lord. In the month of January, your Lord. 20 January, Lordship.
36. Like.
Yes.
Lordship, this is regarding appointment to the post of constable DD
Hmm.
and protection the business by staff selection form.
Hmm.
The year 2020. At page 27, Lordship, clause 11.1.2. It's for negative marking, Lordship. For wrong
How
answer.
do you get it?
page 27, 11.1.2. There will be negative marking for 0.0 marks for each wrong answer. Now,
Hmm.
your lordship comes to page 71, annexure B. That is the type copy. Page 72 is in Hindi, lordship. So the question pertains to what is the maximum length of the touchline in a football match? According to them, the answer is 110 meter. According to the candidate, the answer is 120 meter.
Hmm.
It is supported by documents published by the International Football Association Board that the maximum length of the touchline in a football match is 120 meters.
Yes, what is your stand?
Yes, lordship. In international level football, it is touchline is 110.
But they did not say international.
Here is their additional affidavit, it is mentioned, lordship. And in our advertisement, there is a rule, lordship. Kindly come 11.1.6. Here a provision of appeal is there, lordship. If
So national is 120.
yes,
National is 120.
no, international is 110.
110. National 120. Huh?
As per their
Yes,
this
our-
additional affidavit, as per their additional affidavit.
National is 120.
But our answer case, there is 110, as per our answer case. And there, the board who is prepared the answer case, there was a specialist were there, lordship, who prepared that answer case. And if a representation filed anyone, then on that representation, prayer, it is also scrutinized, and after that, final answer was.
But what is the actual answer? If it is international is 120 and national it is, suppose international is 110 and national if it's 120, then
110 is our answer case.
international.
Yes.
International.
Yes.
The question did not ask international football matches.
It doesn't even say the national also either.
Just says
So which one is correct?
120 meters, lordship.
No, if it is national, national is 120. National.
National or lordship, the question pertains to what is the maximum length of touchline. That is 120 meters as per International Football Association Board.
He said international is 110.
International is 110. But the question did not ask for international one. Lordship will kindly come to the question one.
That's what I'm saying. It's either it's not say the national. You are saying that international 110.
110.
What is 120?
120 is otherwise the maximum length of touchline in football matches is 120 meters. If it is international, then it is 110 meters.
How do I mean by that?
The question did not ask for international matches, lordship. Lordship, there is a very recent judgment of this division bench of this honorable court, lordship, wherein a similar kind of question arise where the question, if I may place that judgment.
Just tell us.
Yes, lordship. There it was asked that which section pertains to India dying declaration in Indian Evidence Act, lordship. It did not mention the year of publication, lordship. For the division, lordship, I'll just place the judgment for that.
Okay, let us decide the first here in this facts first here. I mean, let us see the facts, know the facts first here. But jumping on the judgment, why this?
Lordship, the facts here is that if your lordship may take up the additional affidavit for a moment. The additional affidavit filed by NATRA.
This additional affidavit.
Page 94.
Always there is a difference of pages with the brief of the lawyer and the court. Additional affidavit,
Yes, Lord, page 94.
it's page 84. Yes. Yes,
Page 94, Lordship, dimensions. The touchline must be longer than the goal line.
annexer.
Next one, Lord.
Hmm?
Search from page 91, laws of the game.
Annexer?
Annexure H, starting
Hmm.
from page 89.
From you got it. From where you have got it?
Annexure H, page 89, Lord.
Huh?
Laws of the game. IFAB.
Huh.
Page
From where you have obtained this?
It's from internet, Lordship, from
Internet.
their website. International Football Association Board.
Internet.
Yes, Lordship, from their website.
See,
official
there are, we just cannot blindly rely on this internet.
website. This is
I'm not
football
saying that
website.
it's not totally reliable, but you see, I have encountered, come across. You said, what is brown sugar?
Lordship, brown sugar.
You just type it in the Google. There will be hundreds of definitions. Which one you will agree?
The one relatable to what? This has been printed out from the official website of the International Football Association.
Suppose what is brown sugar? Literal meaning, it explain as one of the meaning is given is a sugar brown in color. Do you agree to that? Will you agree to that? Then, but it is from the Google and from the internet. That
Lordship,
only you
why we
get
have
on this.
sought this information because International Football Association Board controls FIFA.
From where you have got it? You said just internet.
We have got it from the official website of International Football Association.
It's 2016-17.
Yes, Lordship.
Laws of the game. What do you say?
At page 94, Lordship. Part of the document.
It's very difficult. Dimension,
Dimensions.
length, touch line,
Line.
minimum 90,
Minimum 90 and maximum 120 meters. Dimensions for international matches, minimum 100, maximum 110 meters. The question did not ask for international matches. But
touch line, dimension for international matches.
Here not mentioned that whether international three is the touch line must be longer than the goal line.
Huh?
Length, point 3 dimensions. The touch line must be longer than the goal line.
Hmm.
Length touch line. Minimum 90, maximum 120. Dimension for international matches. Touch line maximum 100, maximum 110. Our answer case is relied on 110, Lordship,
Hmm.
as per our answer case. And the petitioner right answers as 120. Therefore, he got negative marking, Lordship.
Hmm.
2.5.
So how do we decide?
Already
You
they-
have not said international matches. You said football match.
international may be applicable, Lordship.
Why? Just because you have chosen to say so.
In our, kindly come to our affidavit, Lordship, we have clarified
What?
page 106, Lordship,
Hmm.
para number 5. That in the instant case, the petitioner, namely Sri Partha Sarthi Sil, son of so-and-so, village so-and-so, expressed an apprehension that the answer key declared by the commission UID numbers is wrong, which has led to his disqualification in the final merit list of selected candidates of the Constable ZD exam 2022. It is the specific cases of the petitioner that although the petitioner fared well in his examination, the petitioner's marks
which ought to have been 67.82 have been calculated 65.32 for wrongful deduction of 2.5 marks on the basis of an ambiguous incorrect question. The question has also stated that he has registered his objection to the tentative answer key in RO that said QID through the challenges management system, but no changes were made by the commission in the final answer key. Number 6, para 6, that the deponent begs to state that as per paragraph 11.1.6 of the notice examination, tentative answer keys of the computer-based examination will be placed on the website of the commission after the examination. Candidates may go through the answer keys and submit online representations, if any, within the stipulated time limit on payment of ₹100 per question. Representation received through any other mode, example, as for example, letter, application, email, etc., will not be entertained. Representation regarding the answer keys will be scrutinized before finalizing the answer keys, and the decisions of the commission in this regard will be final. And as per petitioner, he filed a representation. And on the basis of that representation, already decision has scrutiny also completed, and decision has been taken by the board, Lordship. And it is the recruitment process of 2022. The whole process has already completed. Appointment has been already done. And new recruitment process also started, Lordship.
Examination held on 7th February 2023. The petitioner submitted his representation on their online website on 21 February 2023.
And on the basis of that representation, scrutiny has been conducted, Lordship. And kindly come to page 107, paragraph 8. Here, point 1, here also mentioned that after the completion of a computer-based examination, a notice is published on the commission website giving tentative answer keys of all questions and affording all the candidates an opportunity to challenge any answer keys questions. In the case of the examination in question, the same was done through notice dated 18 to 23. All the challenges, objection received from the candidates are sent to the subject matters experts for their scrutiny and recommendations. The SMEs are members of the academic, that is, they are external independent members, not under the employment of the commission. External members who scrutinize the answer keys, Lordship. The SME examine the challenges, questions, their tentative answer keys, and the challenges, objection raised by the candidates, and give their recommendation to the commission. The commission goes by the recommendation of the SMEs, as in the words of the Honorable Apex Court, academic matters are left to the academics. Thus, if a question has been challenged, there is a possibility that its final answer key may be different from the tentative answer key, or the question may be declared invalid, leading to award to full marks to all the candidates, depending upon the recommendation of the SMEs. If, however, a question has not been challenged by any candidate, it does not go to the SMEs, and its tentative answer key becomes the final answer. And same process is also followed in the case of the petitioner, Lordship. On the basis of that answer key, all examination already completed. The whole recruitment process has been already completed, Lordship. Appointment has also been done.
So according to, had he filed a objection within that time?
Yes.
Matter could have been rectified.
Yes, Lordship.
Huh?
Yes, Lordship. It is a computer generated process, Lordship. We will file, and after that, with a fees also there, Lordship. to file a representation.
We have paid the, we have filed the representation.
And on the basis of that representation, it is sent to the experts, Lordship, SMEs, subject matter experts. And after scrutinized by the SMEs, the final answer key was published, Lordship.
Therefore, there's a two is, I mean, possibilities there. One says 110, 120. For international matches, it's 110. Your answer key says, I mean, the question says the maximum length of touch line of the
line.
football match. Football match.
Here also not
So
mentioned.
how can you use it the international?
As per their affidavit, additional affidavit, they are also not mentioned with the international or national.
It says,
Only international is mentioned.
yes.
Both mentioned. For normal matches, it is 120 meters, and for international.
And our answer case was scrutinized by the experts, Lordship. And
It's
it
all
is,
right. How can you expert? How can be you be wrong? That is, we wonder how the expert, if the expert is wrong, what can we do? Question is very clear.
yes, Lordship, this is,
Football matches, there's nothing like national or international. So dimensions which it is shown without minus the international matches,
all
it's 120.
yes, Lordship, all participants get the marks according to our answer case, Lordship.
But then, if your answer key is wrong, otherwise, if you get 2.5 marks, this is the only question.
Yes,
Only this question, 97 or what? Question number
question number 8, Lord.
8. So otherwise you are qualified.
Yes, sir.
This is only for this thing, written.
Lordship.
It's only written. Thereafter,
PET, at first,
Everything is-
computerized examination, after that, they will qualify, they have to be qualified PET, physical eligible test. After that, they have to qualify physical standard test. After that, they have to qualify detailed medical examination. After that, they will be
Yes,
selected. And
written.
the whole process is completed, Lordship.
No, written.
Written, that is computer-based examination. Where he got less marks, 2.5 less.
Then what is the, if he,
If I get that 2.5, I am above the cutoff.
so what the next stage?
Next is physical eligibility test.
Ah.
I have already crossed all those. Your own
Photocopied to
affidavit says,
computer.
your own affidavit says that I deserve this mark, just because of the deduction of 2.5, I did not get into the selection.
No, this is the, what is this?
Computer-based, for computer-based examination, Lordship. Who completed and got success in computer-based examination. After that, selected candidates go for physical eligibility test, PET. And who complete.
This is what it says.
They come to page 75 of the review.
What is this stage? After this, what will,
Final.
if you are select,
How can
Lordship will kindly come to page 75. for
Ah.
information.
yes,
The result of the candidate Lordship, Constable GD in Central Armed Police Forces,
25?
page 75.
Kuntu.
I mean,
Allocation details Lordship. Then score in computer-based examination.
I don't know why there's a difference all the time. What is Boro?
Page 75.
What's the difference of pages in the court's record and the other courts? Hmm?
Sorry.
Page,
Page 75, Lordship.
there's nothing like that. Page 75. What is this? Scoreboard.
scorecard, Lordship. Yes,
Huh?
Yes, Lordship.
Allocated details.
Details. 4 in computer-based examination, tier 1, paper 1,
Hmm.
65.3209.
Hmm. Huh.
Status of height chest relaxation availed in PET, PhD. No height relaxation, no chest relaxation. Then DME qualified. He has qualified everything, Lordship. He has not been selected because of the deduction of 2.5 marks. And next page is the portion of the select list, annexure F. Your Lordship comes to page 80. Second line from the bottom, Lordship, Assam ITBP. 7.08295, the last cut of mark, Lordship, for OBC.
Your status of height is not required.
Lordship,
Status of height is
already
not required.
PhD qualified, Lordship.
Huh?
PhD qualified.
Where it says.
I have not taken relaxation, Lordship,
Hmm.
for OBC. Status of height chest relaxation availed. No height relaxation, no chest
Okay.
relaxation.
So,
And DME I have qualified, detailed medical examination.
hmm.
So thereafter,
So she is correct. This is one thing. No.
whole process is complete, Lordship. He has participated in all the categories.
Then next is what?
Next is the select list of that year, Lordship. Annexure F, page 76.
Hmm.
The relevant portion, your Lordship will find at page 80.
Hmm.
Since the petitioner belongs to the OBC category, Lordship.
78.
Second line from the bottom, Lordship, Assam ITBP.
Seven-
OBC
78.
67.82.
Which page I'm asking?
Page 80, Lordship. Page 80. Second last line, Lordship.
Hmm.
Assam ITBP. OBC 67.08295.
Assam?
Assam. Then next it is ITBP.
Hmm.
OBC cutoff is 67.08295.
He got 65 point something.
Yes, if that 2.5 marks I get, then it is 67.8295.
Assam what? OBC.
At page, your Lordship found page 80, Lordship.
Yes.
Second last line, Lordship. Assam ITBP into Tibetan Border Police. Then it is OBC category.
Hmm.
After that, on the 7th column, Lordship, 67.08295
Hmm.
is the cutoff, Lordship,
Hmm.
for OBC category.
Hmm.
And if I am given that 2.5 marks, I scored that mark, Lordship. 67 point.
Exactly.
Exactly.
Exactly 8295.
Yes, Lord.
Hmm? Exactly. So if you qualify in the cutoff marks, then you are appointed.
Yes.
Is it so?
Yes.
Irrespective of
They may create.
irrespective of the merit or the scores.
Course, I have already scored, Lordship. That is my scorecard, Lordship.
Sir, there is a difference
Lordship.
of cutoff and scoring marks. Suppose there are 3 persons, cutoff is 70. If everyone qualified 70 more than, suppose if you get 70 and if she gets 75, suppose there are 2 posts, who will be appointed? Just because you are qualified in the cutoff or you have scored more than the cutoff marks, will entail automatic appointment.
If I'm in my knowledge, Lordship, if I'm in the merit list, Lordship, if I have not taken any relaxation, I should get appointment. Lordship.
What is the question over there? I'm asking, what is the system here? Suppose cutoff is 67. If you qualify, if you score 67, automatically you are appointed. Of course, subject to, this you are qualified in, qualifying in the other categories,
Yes,
physical
but
and
what
other
criteria?
medical. So there's no, suppose there are 100 people who have qualified, they'll be appointed. There's no, I mean, question of post. There's no number
The
of posts. is not
Post
there.
is there,
Post is
Lordship.
there, Lordship.
Limited
is
post,
there.
post is
If
there.
there is no post, then they may be directed to create supernumerary post, Lordship.
No,
Why?
that is
For-
not,
for
not,
Lordship.
How can we do that?
no, no.
But wrong was on their part, Lordship. Otherwise, I'm eligible, Lordship. I have answered it correctly.
Obviously, you are a petitioner, you will say so. We are hearing you now. How many posts were there? How many were there? How many appointed? How
There
many
were
persons have been appointed?
That number they will have, Lordship. The total post, it was 24,369.
All India, it's all India level.
All India
Yes.
level, Lordship. For Assam, it is different, Lordship.
For Assam, how many?
That I have to take instruction, Lordship. I have no. How many posts are there for Assam, Lordship?
Is it so that once you qualify the cutoff,
No, yes, Lordship. If two person get the same number and post is one, then some criteria will be.
no, it's
maybe
not the
the-
same number. See, normally it's just doesn't everybody doesn't get same number. Qualified qualification. I mean, cutoff is 67.
Yes,
If there are 20%, 20 posts,
yes,
for example, everybody scored more than 60 or 60 or 60,
yes,
67. I mean, qualifying
yes. Cut-off marks, above
Cut-off
cut-off
marks,
marks.
huh.
Yes,
and they are physically or whatever, their fit found to be qualified. Will all of them, irrespective of the, I mean, scoring
yes,
of the marks,
yes.
once they are qualified, I mean, above 67 and above, all of them will be appointed.
No,
In
Lordship.
that case, if someone has taken, if I may, Lordship, if someone has taken relaxation his age, then he will not be selected, Lordship.
Why?
Age relaxation.
Is relaxation not for Assam, Lordship? For
I'm
Assam.
not
it
getting
will-
are you getting what I
Yes,
trying to? I said, suppose there are 20 posts, right? Qualifying marks is 67.
Lordship.
If there's, if candidates, I mean, if 25 or 20, 30 candidates qualified everything, including the qualifying marks, then all of them will be appointed, even if there are 20
post, no.
posts. Then what is the criteria? Criteria. You have to fill up only 20 posts
No,
and 30 candidates, they have qualified,
yes, Lordship.
having the different marks. Someone 67, 68, 69, 70. Obviously, the person who scored more, he'll be selected. That's why I'm asking. Just because if this marks is given to you, you exactly qualify. Is it a automatic? I mean, that's why I'm asking. Automatic. Once you are qualified, irrespective whether this is a post or not, you will be appointed. No, that cannot be. So we don't know. Suppose for a time being, for a moment, we'll accept your submission that they have committed wrong. You are entitled for this 2.5, which makes you qualified. Right. Will it entails automatic appointment? This is what I'm asking, or the selection. Because there must be some persons, some candidates who scored more than you. How can you be denied? Because of the wrong action or illegal action of the part of the person to make you disqualified or disqualifying you is one thing. Selection appointment on being just cross or qualifying the cutoff marks or scored the cutoff marks, will not be, it will be another thing for appointment and selection. That's the reason I just wanted to know, isn't it?
Yes, Lord.
Just because you are qualified, cannot be appointed automatically. There must be some candidates who have scored more than you. Therefore, even if you, accept your submission, there must be some number of posts, how many candidates got how much mark, what is their total marks obtained, that has to be looked into. Otherwise, suppose if we allow also, if you have just because you have eligible and you should be appointed, cannot be. That cannot be blanket, isn't it? You find out that.
Let them bring one instruction also, because that they have to bring also.
It's your duty also to find out. Heard Mr. So-and-so learned counsel for the petitioner and Mr. M.S. Esboro learned CGC. After hearing the learned counsel and parties for some time, it's some length. Come on. It is seen that and it is noticed that no records, nothing is discernible from the records as to how the selection and appointment is made on qualifying on scoring the qualifying or cutoff marks. As it would not be possible, it may not be a case that once a candidate qualified, scored the cutoff marks, same would entail automatic selection oblique appointment. Listen. In view of above, considered above, let the parties to obtain instruction as regards the actual criteria, oblique procedure for selection and appointment. Find out this, all right? List the matter after 3 weeks.
Public.
After 1 week, I will go through the case.
Huh?
I have to read the case thoroughly. I think not 31.
After 3 weeks,
All right.
on the prayer of Mr. R.C. Saikia, Learned Senior Counsel, and prayer note, Learned Counsel with respondent Mr. Subject to Mr.
It's a property for state respondent.
And Mr. Gupta.
No, I am not there.
Come on, let this matter be listed after 3 weeks.
Item 33, my lord, is 2008. And I am saying not before vacation, my lord.
Not possible,
Some
sir.
agencies-
You know that. Not possible at all.
They are very suffering, my lord, poor employees, my lord. From 2 years, they are under termination without salary.
Unhelping.
My lord, can
Next year, first week, second week. First week also not possible. Second week.
8, my lord, already given. I was just praying, my lord, because personal appearance was there, my lord, goes to the order. That's why I am not
We'll see.
pressing, my lord. Since personal appearance was directed, my lord, it would Diana. That's why, my lord, it will only come for orders, my lord.
Is there. Who has been, who has to appear personally?
The district commandant, Home Guards, my lord, he was directed to appear in person if the instruction is not produced. Only small, my lord, if they produce that instruction, my lord, it can be resolved.
At two, in that case.
My lord,
At two,
my lord, my lord.
we'll see.
My
You
lord.
inform the other side.
I will inform you.
Yes.
The instructions were sought, my lord. The basic grievance, my lord, was that the petitioners were, my lord, removed from service, my lord, without any show cause, without following any principles of natural justice. And, my lord, on the ground of punitive, as a punitive action, my lord, their services were terminated.
Yes.
Now, my lord, in terms of the last order,
Yes, I have seen it. Yes, madam.
my lord,
Finish, Lordship.
Lord, whether they have issued the show cause notices or not, some inquiry is going on, my lord, they have filed an affidavit. To that aspect, my lord, the honorable court wanted to clarify whether any show cause notice was issued, and if issued, whether those were served upon the petitioners or not. My friend will clarify.
Lordship, regarding the contentions of the petitioners, our affidavit is very clear, Lordship. We have filed an affidavit on behalf of respondent number 4, Lordship, wherein in paragraph 6, we have stated that the petitioners are not terminated, Lordship. Their the post has been kept on hold, Lordship, because pendency of a enquiry, Lordship. So regarding this, Lordship, first show cause notice issued, he did not respond. This was in August. I have the record, Lordship, and it was served to him, but he did not respond. Then again on 18/11/25, show cause has been issued. Now he has replied on 21/11/2025, Lordship. So as he has already filed his reply, Lordship, I think the next procedure will be held and accordingly enquiry will be concluded, Lordship. So this is,
Yes.
so this is our instruction, Lordship.
But this, what is the date of that show cause, my lord, whether it was served or not? Let my learned friend clarify on that aspect, specific direction, my lord, that paragraph.
No, forget about that. We'll see, we'll come to that.
My lord,
The main issue is, suppose if you have not terminated, how can you say that you have been terminated?
Yes, Lordship.
This inquiry is going on.
This is the categorical statement.
No, yes, to that aspect, my lord, I will submit, my lord. First,
This is in Hindi, Smith.
Yes, Lordship,
How
all
do I
in
know?
vernacular, yes, Lordship.
Huh?
Yes, Lordship.
What is this? It's a notice. It's a reply.
The first one is reply.
Yes.
The petitioner, Lordship.
Then
Then the next one was the latest show cause, Lordship, of 18/11/2025. Before that, there was another, there are other, Lordship, bunch of, that means volunteers are there, Lordship, whose cases are, they are been taken together and they are been, that means enquiry is going on in respect of all these, Lordship.
But when
So I have obtained the whole bunch, Lordship. This could not be differentiated. But the first three pages are meant for the present petitioner, Lord, in respect of the present petitioner.
Let them, my lord, file it by way of an affidavit, my lord, in that case. Lord, let them file this by an affidavit that they have issued and so forth, my lord, we will reply.
Who is this other
Lordship.
page, this last page?
First
Order,
page is Lordship in pertains to another case, Lordship, because I have obtained the whole bunch. His proceedings and inquiry has been concluded.
Whose, my lord? There are 10 petitioners, my lord. There are 10 petitioners. Which petitioner he is referring to, my lord? That may be
name
clarified.
is Tarun Gogoi,
Arun Gogoi, he has been, yes, Lordship.
exonerated,
Yes. And this is admitted by them also in their affidavit in reply.
admitted.
Yes, Lordship. But in
Exon-
other
He's
cases,
a
Lordship,
petitioner.
the petitioner.
Yes, he is
Tarun Gogoi is petitioner.
Yes.
Yes.
So he's
Yes,
exonerated.
Exonerated, my lord, he can be, that is there, my lord. What
Ah.
about other petitions, my lord?
They said this inquiry is going on.
Lordship.
Lord, where is the
So
show cause?
Lordship may.
Lord, where is the show cause?
It's here.
My lord will see the date. Lord, I have.
It's all
read-
in Assamese.
No, my lord, she can tell the date at least, my lord.
I
Ah.
already have stated,
What
the
is the
last,
date?
on the, can I be dictated by the counsel for the petitioner, Lordship?
My lord-
I have to submit before your Lordship,
May go
not
to
to the address to
just
the
wait.
petitioner.
Just wait.
This kind of attitude cannot
Yes,
be
sir.
tolerated. This is nothing
Our
personal,
categorical stand,
nothing
my lord,
personal.
Was that no show cause notice was issued, my lord. That is a very categorical stand we have made in the writ petition. Affidavits been filed by the government. At that time, my lord, no such inquiry, show cause notice was produced by them.
So what is 26/11/2025?
26/11, my
Yes,
lord,
Lord.
my lord will see their affidavit. The affidavit filed by them is of 10th September 25. On 10th September 25, my lord, they have not made any such averment. that
No,
the-
no, this is reply is 26/11.
How can it be, my lord? This is recently, 26/11.
Yes, yes.
Show cause cannot be after the affidavit, my lord. During the pendency of the proceeding, they are issuing.
No,
show
no, I'm
cause.
saying it's your reply,
Yes,
26/11/2025.
That is by respond number 10, my lord. When was the show cause, my lord? I am also not aware. When was the show cause notice issued?
It's all in vernacular. Can you read?
My lord, yes, I can read, my lord.
Huh?
Yes.
But equally, since you have submitted, why you have not brought to notice?
My lord, these all are happening.
What is your case?
My
You are
case
saying that
is-
you have been terminated without
Yes,
inquiry and without notice?
yes, my lord.
Yes.
Yes.
Now there is standing that notice was issued?
That is recent.
No, no, just wait, just wait,
During the pendency.
just wait. In
Even today, I
affidavit,
have not received, my lord.
affidavit, they said,
No, they
In
have
aff-
not said in the affidavit about show cause. They only talked about some inquiry is going on. That's
Ah.
why, my lord, there was a specific direction at paragraph 4, if I may read.
no,
On the
no,
next-
first, let us see your, we'll come to that. Your prayer, what is your prayer?
Pray in the writ petition, my lord.
Yes,
Yes. Should not be,
should
my
not
lord,
be
redeployed,
redeployed, re-engaged back
re-engaged
on
back
duty
on
in
duty
terms of the
in terms
communication
of the
with the-
communication with it.
What is this communication?
My lord, this is at page 46, my lord.
Forty-six?
46. Typed copy is there. With reference to the subject above, I would like to inform you that we have submitted a list of homeguards 106 in numbers in the above reference letter to your good office, requesting not to re-engage, redeploy in any duty as homeguard volunteers in future for various reasons, that is arrest, involvement in criminal cases, unauthorized absence, negligence of duty, indiscipline act, misconduct, illegal activities. Now I am directed to request you again not to re-engage, redeploy those homeguards in police commissionerate. However, this establishment has no objection if they are deployed in other district of the cognate. That is what we were praying, my lord. Initially, when we were working in the police commissionerate, my lord, due to some allegations, my lord, without following the principles of natural justice, I was disengaged from the police commission.
Where it is?
That is included, my lord, at page 45. If I may read, my lord, page 45. it
The
is
following
purely
home guards.
cumulative. The following homeguards of the police commissionerate, Guwahati, deployed in different places as shown against each of the names who have criminal records. Past history of misconduct are hereby discharged. Now, my lord, when this order was in existence, my lord, I approached the district commandant Home Guard in terms of this page 47 order that, my lord, redeployment in other organization is not a bar. So therefore, my lord, I prayed, my lord, that I may be redeployed. But the authorities said, my lord, since there is an order of discharge, we are not going to re-engage. Now, this order of discharge is also without following the principles of natural justice. No show cause, nothing. The inquiry proceedings or inquiry, my lord, documents which now have been produced, it was never stated in the affidavit by them. It is only during the course of the proceeding. Even today, my lord, I am maintaining that stand that no show cause notice has been given to me. The entire case is, my lord, my entire case is based on that. Even, my lord, in my additional affidavit, my lord, at page 139, my lord, during the pendency of the writ petition, my lord, page 139. That, my lord, at page 139.
Anyway, we'll provide them. You file an additional affidavit.
Lordship.
File an affidavit
Yes.
bringing on this record as per the order of this court, 1811. That will be better, right?
Will
Art
reply.
Master H. Gupta, learned counsel for the petitioners. Next para. And in deference to the order of this court, that is 18/11/20, no, in deference to the order dated 18/11/2025. MS M. Bhattacharjee, learned additional senior government advocate, has submitted a bunch of papers as regards the notices oblique the replies, so-called notices, notice oblique so-called replies against the, in respect of the petitioners, and submits them. The inquiry is still, inquiry is going on against the petitioners, right?
Lordship.
However, my lord, my
One
submission
is
is-
exonerated lordship when we have
Parental-
admitted this in
Parental
our
of
affidavit.
the documents, which is in vernacular, huh? Which is in vernacular. List of
My lord,
in
my
such view of the in view of the above, MS Bhattacharjee is directed to bring on records the documents which he produced by annexing and also to translate the records, the documents.
Lord, paragraph 4 of that earlier order, if I may read, my lord, that direction may also be given, my lord, that they should clarify whether the show cause notices were actually served upon.
In terms, Mr. The affidavit
Also clarified.
be filed in terms of the order dated 18/11/2025. You go through this
Lordship, yes, sir.
as per this, what is
Yes,
that?
Lord.
You were asked to do,
Yes,
you
Lord.
as per that you
Yes.
bring on record,
Paragraph
right?
4 of that order, my lord, can clarify that.
I'll return it.
My lord, add paragraph 4 of the order. Paragraph 4 is a specific.
No, it's okay, as per the in terms of, let her read.
They are making up the.
Why we should,
My lord, we'll fix
why you should pass an order and clarify again and again?
My lord, we'll fix a date, my lord. I'm humbly praying, my lord. They are suffering, my lord.
After 3 weeks, 3 weeks.
My lord, 8 January, it's a date maybe.
8 January is
8
not, may
January
not be
was fixed
possible. I think
earlier.
we have fixed so many matters.
No, my lord, earlier this matter was fixed 8 January, my lord, we'll fix it.
Okay, then 8 January.
My lord. 8.
First time it was fixed 8 January.
Yes.
This,